May I have a lordship's leave to mention one matter? I would like to move it as unlisted motion or listed motion tomorrow. Because I tell lordships, I have been selected as the principal of the college by the commission. College has also given appointment letter. But my earlier college is not giving the release order. I have to join within a month. In the meantime, because of the new government came up, there was a vacancy. Managing committee no longer functioning, governing body. So I have to address to the HDO local, who is with the administrator. I have addressed it. Similarly, unless I give the release, my appointment will go within a month.
Within a month?
Within a month. Month is going to expire, has expired. Because there is a gap. So they are saying unless you get it, I cannot allow the join. The release order is not being issued with
No,
that.
I understand, but then you file it in the department. Why it has to be taken up?
It will go
today?
down your lawsuits to that.
Down means
Down
where?
in the list, 500, 600 number.
Go down in the list.
That's your
There's
list.
so many, all new matters will go down. The old matters are giving
It is the urgency, my lord. The appointment letter will go. That's the urgency. I want little protection.
File it tomorrow, it will appear. Is it affirmed?
No, this is not. It's to be affirmed. But a day after
affirmed.
tomorrow, your losses can take it. So
Friday.
that I can serve upon all.
Friday.
Much.
Lordship, under huge urgency, Lordship, I am taking your Lordship's leave to file this matter, Lordship. The petitioner is a student. He has qualified Z main exam, both the rounds, your Lordship. But during the document verification time in round A counseling, Lordship, because of one document, petitioner couldn't complete his verification and he lost his seat. That the due document was published by CBSE the day next, because 11th of August at 5 p.m. all the verification proceeding closed, and on 12th of August the petitioner received that document, the pass mark sheet of CBSE exam. Petitioner has written several emails on 11th as well as 12th to accommodate him, because he has not received that pass mark sheet which is required for the document verification.
How could the others get if you couldn't get it? The others, everybody got it. How is that it is you only didn't
No,
get it?
Lordship, petitioner was qualified as a ST category student, Lordship. Only he got qualifying marks, that is 67% in class 12 board exam. Only he got compartment in mathematics. That compartment result came at 12.
Yes, so there was some problem. It is not that it was the problem with the authority.
But Lordship,
It was your problem.
no, Lordship, it was not my problem, Lordship. Lordship, kindly understand, Lordship. The thing is that in IIT Roorkee this year also, Lordship, IRB Roorkee has extended its time, and in larger bench also, Lordship, Supreme Court has also allotted, because of the students who have received belated mark sheets can be allotted, and by through us supernumeric seat, Lordship, can be created. And the petition, because the petitioner has no fault, your Lordship, his result he got the next day.
All right, is it affirmed?
Yes, your Lordship, it is affirmed.
Friday it will appear. You serve notice upon all that.
Lordship, the direction may be passed, Lordship, to give short notice, and it on Friday.
You serve.
Okay.
Yes.
I'm grateful to you, Lordship.
Madam, may Lordship sleep to mention one matter, my lord. My lord, well discussed matter. That is, my lord, the tainted, untainted candidate. My clients are the untainted candidate declared subsequent to the order of the Honorable Supreme Court. Now, my lord, the one person went to the Honorable Supreme Court. Supreme Court passed an order, if grievance to be, my lord, the agitated before the Honorable Court. But 31, your lordship know that 31st is the date, my lord. We will lose the, my lord, the
Nobody
service.
is going to lose anything. What is your apprehension?
My lord, as per order of the court, my lord, 31st August is the last. But we are the untainted candidate. We have collected the OMR sheet.
Yes.
Subsequently, it has been published.
Yes.
But we have seen that, yes, we are, my lord, the successful and all these things.
Yes. So what is to be done now?
My lord, we made a representation to all the authorities. Kindly protect us. Otherwise,
What type of protection?
my lord, protection is this, that when the, my lord, we have been declared as an untainted
Second
candidate after
SLST
publication.
Second SLST selection process is still on. So it is the
That is
Commission's
true.
responsibility to approach the Supreme Court. And this is what has been submitted in court, that steps are being taken to extend the time.
Well, unless, my lord, they do it, my lord, we lose
What
our
will,
job.
what will
My
the
lord,
court
your
do
lordship,
further?
what I am praying, my lord, we want to pave the way from this court so that we can approach there. Because unless, my lord, my lord, certain matters,
File it in the department. No advantage Priority, nothing of this sort. Yes.
My lord, with your lordship's leave, my lord, precarious situation, my lord, on 17th, a matter has been, on the date of the resolution, my lord, matter was mentioned with your lordship, and your lordship had been pleased to dispose of the said writ petition, my lord. I was instructed to appear on behalf of the school authorities, respondent number 6. I would just like to tender my appearance because the matter was made not today first. Thereafter, later on, after the next matter was taken up, thereafter the matter was mentioned and it was disposed of.
What can be done?
Or it can be brought on as to be mentioned, and my appearance could be, because otherwise,
The entire order is there, and now only for recording your name it will become as to be mentioned.
my lord,
No, I'm
otherwise, my
sorry.
lord, otherwise the
Your
respondent number-
responsibility, I understand it was your responsibility to appear, but then I don't know.
Otherwise, my lord, what happens is, my lord, I understand, my lord, it was nobody's fault. He mentioned the matter. The other side, other respondents were there. The matter was taken up, my lord. But my
Maybe
lord,
your presence was also not required.
no,
maybe.
not required, my lord. Otherwise,
You were made a party and
no, but since, my lord, there is some in remarks in the orders as to the non inaction on the part of the school authorities as well, who is myself, respondent number 6, my lord. It would be very
come up with an application in a disposed of matter. It's very difficult only by mentioning to get things
Malad.
done. Yes.
I'll do that.
Lordship, I'm mentioning for upgradation. Lordship, this is a pension matter wherein your Lordship, by order dated 16th of February, had directed the District Inspector of School, North 24 Parganas, to disburse the pension within 8 weeks. That has not been done. In respect of that, a contempt application is pending. The original writ petition is appearing as item number 200. Lordship, in the meantime, urgency has arisen because on 24th of August, my house is going to be auctioned off in a surface proceeding. Lordship, I'm praying for upgradation as the matter is.
You think by 24th of August you will get your pension? The
Lordship,
matter is pending in the list. Is it possible?
Lordship, I'm praying for upgradation. Lordship, there is
The ground that you've taken for upgradation is not a good ground. So next time when it is mentioned, chance is given to mention, please mention. Yes.
May I make to Mr. Malad, I am doing my prayer, what I made yesterday, it is now in the list, my lord. Item 227 of your lordship's list today. My lord, why I am submitting this for your lordship? My lord, for 10 years it has not, any push from the court will at least move the file.
Which file?
My lord, that granting aid matter. Any push from.
Friday it will appear. You give notice to all the other side.
Lordship, I'm mentioning for inclusion of a restoration application.
Today is not the day for mentioning. Please don't mention.
My lord, it's urgency. I am seeking leave to file this matter. This is a transfer matter. The wife of the petitioner is suffering from cancer, so she is undergoing medical treatment, and the petitioner has to visit her regularly. So he is seeking transfer. It is that.
It is a form. File it in the department.
Lordship, may I leave to mention, my lord, one matter yesterday I have filed and obtained the filing number, matter relating to the registration of the, my lord, the son of the petitioner. My lord, petitioner is a, my lord, divorce lady. My lord, this registration of the mother is a divorce lady.
Divorce lady.
Divorce lady. Now, this, my lord, registration is going to be completed on 25/8/2026. My lord, the son of the petitioner has not been allowed to, my lord, to keep the registration, or the petitioner has not allowed to sign the document.
Why?
My lord, the only count of the diversity, and this, my lord, the petitioner is also, my lord, he's asked for the birth certificate. My lord, his birth certificate, that son of the petitioner recorded is Srijit Ganguly. Now it has been, my lord, all papers and documents, they have been prepared in the name of the mothers. He is staying in the custody of the mother, Srijit Haldar. Now the petitioner has not been permitted, as it has been recorded, all Aadhaar card, bank account is the Srijit Haldar, who has not been allowed. He asks for the birth certificate. Birth certificate cannot be, my lord, changed.
Why? You can go and change it. There is a
Well,
procedure to do it.
But at the short period, that cannot be. They
And
have
the
been
court-
last. That
Court is going to help you
no, no,
out.
no, no. They have been last request has been made to the 5th August 2026 to the board. Board is the tight over the matter.
Yes, board will not do anything till you get your birth certificate rectified. Please do whatever is required to be done. Yes. What is the matter about?
Matter is about, I have joined this service from 2001, and every time it was against a advertisement published in the Statesman, and this was the advertisement.
Yes.
And accordingly, I had appeared in the interview. I was selected. I was told to join, and then they would give me as a missionary teacher. And ultimately, my things will be confirmed. I was teaching with wholeheartedly, and simultaneously next year, this way, the school went on putting it. But thing is that I went on teaching, and ultimately, they have sent down my confirmation also. I mean, the teacher in charge to the DI, and he was not responding. And hence I came back with first petition. I mean, with a writ petition first time. They said that no, it is. I mean, it
What
is.
is the immediate challenge, you please say?
I have only 4 months left.
Yes.
And the problem is that the TI office, now they are saying no, there is no vacancy, and it was not done. If Lordship kindly comes to page 82, I mean, they have repeatedly said my 6 writ petition also have been just done away with, and today I've become a ping pong ball.
Listen, there is a law and there is a
Yes.
procedure as to how it is to be done.
Yes,
The school, is it an aided school?
yes, it gets the DA from the.
It's a DA getting school. It's not an aided school.
Yes.
So there is a manner as to how the vacancies are to be filled up. If you were appointed by this school, it's
Yes.
the school's responsibility.
Lordship,
Why will the state take your responsibility?
Lordship, it has gone on from 2000. They have said that it was a sanction because
It is not a matter of they saying.
Yes.
What is the position in law?
Actually, Lordship,
There is a law. According, where is the impugned order?
Lordship, if Lordship kindly comes to page 80,
82.
82. I mean, this is the impugned order. I mean, 83. Sorry, 79. Page 79. Last.
What do you teach?
Commerce, and I'm a full-fledged master's degree holder.
No, but no problem with your qualification. Everything is all right, but there has to be a sanctioned vacancy where you can be regularized.
They had advertised in the for Sri Maestri Vidyalaya Higher Secondary English Medium School.
When you saw the advertisement, when you put in your application form, you knew that this was a DA getting school. You were not certain as to whether your service will be regularized or approved in future or not. You have rendered so many years of service, and now you say that the state has to take your responsibility.
Lordship, actually, the whole thing was sent down. I mean, there were 3 vacancies, including mine. Now, if Lordship comes to page 82, they have said that other things are. I mean, it was sanctioned, but that commerce stream, it is not sanctioned. But 897 students were there, and I was regularly teaching. And
You are going wrong somewhere. Your teaching is not in question. Question is a vacancy where you are to be approved, right? Where is that vacancy? I can see page 82, one line is underlined,
yes,
where it is mentioned no letter of appointment was found issued by the school authority.
Yes, initially, but 2007 onwards, if Lordship comes to all my applications, they were saying me that yes, it will be given. I was going on, but 2004 onwards, the teacher in charge was sending down to the DA office. He was not responding, and hence I came into the writ petition.
No prior permission also
Yes.
taken. School authority offered a letter 2004.
Single bench, it was approved. Last 26 years, Lordship.
School Education Department by approved. Letter on the school authority an appeal. Where is the honorable education partner?
ওই যে ডিস্ট্রিক্ট উপরে হ্যাঁ না এই যে is made out the petition approved কোনটাই
What is the error in the order? Page 85, what is the error?
that is they are now saying the vacancy is there.
Where is the vacancy? It doesn't say. It says
The vacancy is
BCom,
there, but
MCom qualification cannot be placed for the senior secondary school.
yes,
The process of appointment of the petitioner in the school is in question if the school authority appoints any teacher without any prior approval. Considering they concerned, they might have done that ignoring the existing procedure and the specific of the extant government order.
yes.
Right. Then
Page 84 middle place. There is no doubt that the petitioner, by virtue of the long association with the school and his postgraduate qualification, eminently qualifies to be considered for a permanent post in the commerce stream of the higher secondary section. But the petitioner has to wait till a vacancy arises in this regard. As of now, there is no vacancy. The two vacancies being for economics and mathematics teachers. The petitioner, as a core commerce man, cannot be appointed as either. As a consequence, the order impugned is set aside. But
there was an order of appointment of your approval of appointment which stood set aside.
yes,
Right. So nothing remains in your favor now. It is only if there is a sanctioned vacancy in the commerce stream, you can be accommodated. Where is that vacancy?
recently they came up with it
Where is that vacancy?
because they
Where is it? Did you serve the school?
actually the school has been standing with me for from 2007 onwards. They have been sending down to the DI and
Show me that there is a vacancy, sanctioned vacancy. Where is that? Did you serve the school?
we have served the school.
Who appears for the school?
Actually, the whole thing panel and everything has been.
What
School has
has-
nothing to do with the
Yes.
panel.
What has the school got to do with the
I have already
panel?
said, but
The
Yes.
school's
school has nothing
concept.
to do with the panel.
Did anybody appear for the school on the last occasion?
Yes.
Shoktipada Jana.
Last location.
Where is Mr. Jana?
Yes. Mr. Then will if Lordship kindly comes to page 34 once, Lordship.
No use going back. You show me that there is a sanctioned vacancy.
Last we were this page 34. Yes. It is to draw your kind attention to the papers regarding the approval of the teacher for a service of teachers of the school were submitted on 8/10/2007. In your
I require the presence of the school. You please call. Please come. None appears on behalf of the school, which is a DA getting one. Stop. The petitioner is aggrieved by the order dated 5th August 2024, passed by the District Inspector of Schools, Secondary Education, Kolkata, rejecting the petitioner's prayer for approval of his appointment on the ground that there is no sanctioned vacancy where the petitioner may be approved. Stop paragraph. The presence of the school will be required for effective adjudication of the instant writ petition. Stop. Let notice be served upon the school and the learned advocate representing the school. Release the matter for further consideration next Wednesday.
Well, what I could fathom, my lord, from the documents is, my lord, there have been series of writ petitions. Every time, my lord, it was sent back to the Commissioner of School Education, and every time, my lord, his plea was rejected.
On the plea that there is no sanctioned
There is no
vacancy, but this person is in service for quite some time,
Hmm.
and there
And-
is a vacancy in the school. But
Whatever
then-
is there, my lord, is of 2024, my lord. There is no document in the writ petition, my lord, which is of the current date.
If
No document.
24 vacancy remains, if the petitioner can be
Remains?
accommodated, then you can
May I
accommodate
also
the
come back with the
petitioner.
report also in that event?
You also,
Let's also come back.
the pupil-teacher ratio, which was important in the last matter, whether that is
There.
conducive enough to accommodate the petitioner.
Absolutely.
By next Wednesday, please
I will
come
come
with
back
the
with the report.
learned advocate representing the state respondents shall obtain a report from the district inspector of schools as regards the pupil-teacher ratio in the subject.
My lord, only one thing, my lord, if your lordship is entertaining this petition, lordship will kindly come to the short list of dates. Lordship will kindly. My lord,
Why? Say why? Wrong.
No,
Tell what is said.
it is the name of the, my lord, the honorable judge is written, my lord, without, my lord, any prefix of it. At least my lord, they should correct it. This kind of, my lord, coming from
Sir,
advocate, my lord, is not, my lord, acceptable.
call the next matter, please.
Kindly.
I beg to appear on behalf of IISWM, my lord. আজকে আমাদের বলার কথা না, তোমাদের বলা তো হয়ে গেছে।
But Mr. Mojumdar was arguing, my lord, he wants to add another judgment on recent judgment of the Supreme Court. But difficulty is, my lord, he could not come to court today due to personal difficulty. I was praying, my lord, any day. I don't keep it tomorrow because I don't know. Yesterday also he could not come, so next week anytime, my lord.
Accommodation has been sought for on behalf of the learned senior counsel representing the petitioner.
না কালকে না বলছি next week
Release the matter
but kindly keeps it next week any day, my lord.
next Wednesday.
Next Wednesday.
Let My lord, this correction, my lord, paragraph 2. Your lordship cited the petitioner 6 house rent allowance. Her house rent allowance is due from August 2022. It will be July.
Second line, paragraph 2. August should read as July. Where from you get to know it is July?
Page 19. Salary sheet.
19.
Page 19 of the petition. My lord, HRA. HRA annexure P2, my lord. Page 19.
Page
HRA.
19, HRA,
Up to July.
June of the year. July.
July has not been given.
All right.
Actually, two matters were taken at a time wrongly put as well.
Other one was all right.
The other one is also, my lord, that will be August 2024.
24.
24. Not 20, because he was transferred and subsequently.
Where do I get that?
My lord, kindly turn to page 25.
25. HRA.
Oh.
June 24. You are getting HRA in June 24.
I've got five. No. Well, wait, I'm sorry. It's nine. It's nine. Oh, sorry. Wrong petition has been filed. Yeah.
26,995.
Well, it's 24. Sorry. 24 August 2024, HRA 0.
22 will lead us 24.
I'm grateful.
This has come up at my instance. Kindly seize your lordship's last day order. Lordship was directed. Kindly seize the order. Longish order. Kindly. May I just place the order? After this, my lord, they have issued a notification by which, my lord, they have totally ignored the crucial date. May I just place it? Challenge paragraph 3 onwards.
Which order? Date?
Dated 23rd June 2026.
23rd of June.
We took an order on it. Order to mark something. 25th June. Okay.
Yes.
The challenge in this particular is with regard to the reservation of economically weaker section shorts, EWS candidates. As per the recruitment notice, the candidates seeking reservation under EWS category, if shortlisted for interview, must produce income and asset certificate issued by the competent authority valid for year such and such onwards, issued financial year such and such during checking of testimonials. 2 notices were published by the recruiting board on January 2026, wherein paragraph E of one of the notices, it has been mentioned, income and asset certificate 2024 or onwards. And in the other notice, in paragraph E, it has been mentioned as income assets for the candidates belonging to economically weaker section valid for 2023-2024. Specific case made out by the petition is that the period of reservation certificate relied upon by the candidate should be a fixed one. The same ought not to remain open-ended. Crucial date is very important for the purpose of obtaining benefit under EWS category. In support of such submission, reliance has been placed by the petitioner on a judgment delivered by the Honorable Supreme Court in Gaurav Singh, Divya. Reliance has also been placed on such and such. This is your lordship's judgment in SLST matter. Frequently asked questions on reservation with regard to any economically weaker section in the post services under central government, answered by Ministry of Personnel, Public Grievance and Pension Department of Personnel and Training, Government of India, dated 19th September 2022, annexed to the exception filed by the petitioner to the report filed by the state, has also been relied upon in support of the principles of crucial date for importance and assess for income and asset certificate. Submission is that recruiting authority ought not to rely upon any certificate which has been issued after the last date of submission of the application seeking recruitment. Yesterday, a day before yesterday, lordship has passed an order also in NWT matter. And thereafter, I'm skipping the CAN 1, CAN 2 is learned senior friend is appearing. The CAN 2 applicants in such and such relied upon financial certificates issued in their favor after the last date of submission of application. Accordingly, applications, notice, permit file, such and such. Paragraph 14, the submission I'm disputing, I'll show documents to that effect. The applicant submits that recruitment notice is not under challenge. The petitioner has approached this court long after they were declared unsuccessful in written examination and were ineligible to participate in the interview. We were declared all successful. I have annexed document. Learned Government Peter relies upon the report affirmed by Deputy Superintendent of Police and submits that recruitment is being conducted strictly in accordance with such and such. I'm skipping over. Kindly comes to, yes, paragraph 20. State respondents are directed to file a further report in the form of an affidavit disclosing the circulars, government orders, rules, regulations followed by the state for the purpose of issuance of income and asset certificates in respect of an applicant. Learned government pleader shall address the court on adjourned date as to whether the recruitment notice is in line with the law laid down by the Honorable Supreme Court in the manner of Divya Gaurav Singh, particularly with regard to the crucial date of the income and asset certificate, whether the period for which the certificate is to be considered can be left open-ended, and whether any certificate issued after the crucial date can be taken into consideration for ascertaining the eligibility of the candidate seeking reservation on financial grounds. Can 2 such and such directs to file an affidavit clearly indicate the date on which the applications were made for obtaining the income and asset certificate. Now, Mala, this has been given by the clients of the learned senior friend. One date is there are 2 applicants. One applicant has described herself as a non-EWS and has subsequently applied for EWS. Another applicant has described himself as an EWS category but has applied subsequently. I'll show. But as of today, my lord, kindly takes up, my lord, the affidavit which has been filed. Affidavit has been given to us by the affidavit copy there by the state government.
Is the state present?
We have been served with the affidavit, my lord. What has happened? Kindly seize the exception. Amader exception tate. Original tate. What they have done, kindly seize the exception filed by us to the second report. Original tate. This is the exception. Justice Mantha order tate. আর ওদেরটা ওদের second report tate.
This is in the writ petition, isn't it?
This is in respect of the second report filed pursuant to order of this honorable court.
In the writ petition,
In the writ petition.
not the application.
No, I am on the writ petition. May I just give their, my lord,
Report.
no, their report, their second report. Give their second report. Since they are not there, we give our copy. এইটা do you have another copy? Yes, kindly seize. This is, my lord, the copy given by the government. এটা তো half কেটে গেছে রে ভাই. Kindly takes my copy. This is marked, but kindly returns this.
This matter was returnable on the 21st of August.
Yes, 21st. This is the reason why this has been, my lord, preponed. Kindly seize.
Is the state put on notice?
Yes, state was put on notice.
Because nobody is appearing for the state.
I'm told, my lord, Miss Ranjana Chatterjee was appearing.
Yes.
But, my lord, I don't.
And what has happened? Why the urgency? Yes. Kindly comes to page 30 of the exception. Yes. Please kindly comes to page 30 of the of the exception.
Yes.
Oh, not 30. Just a minute. Yes, page 28.
Reported exception.
This is the latest notice. This is the urgency. Now, what they have done, in the meantime, the OBC category has been cancelled. Kindly read page 28. In terms of the notification dated such and such, OBC category has been cancelled. What they have done in pursuant to the latest notification, second last paragraph, the candidates belonging to such and such who have appeared in the interview for the recruitment to the post of constables in West Bengal Police are advised to upload their OBC certificate clearly mentioning their class to get benefit of reservation under OBC category as per the latest state list. They should upload their caste certificate by clicking the link to be made available on such and such. So therefore, out of the 66 categories, only these 2 categories have been invited because they were previously there and their names are now subsequently, that caste has also been included in the subsequent. Now, candidates who were under the OBC A or OBC B category at the time of their interview, but presently excluded from the state list of 66 classes of OBC, if possesses an EWS certificate which is valid for the year 2023-2024 or onwards, will be treated under EWS category subject to uploading of their valid EWS certificate using the above link. So therefore, these persons who are the other OBCs, your lordship has been pleased to reject one application where, my lord, they had sought for change of category. Lordship remembers on the same day, 14th August, 19th, 14th August, on the same day your lordship was pleased to. So they are allowing these OBC A, OBC B category candidate to change their category and come into EWS, totally disregarding the crucial date concept. Crucial date, as has been laid down by the Honorable Supreme Court, upheld by your lordship in several decisions, is the last date of submission of the application. Now, my lord, they have also allowed these OBC A, OBC B category candidates who, pursuant to the judgment of the Honorable Division Bench, has to be treated as a general category because their categorization has been cancelled. They have been now allowed to give their, my lord, options in EWS certificate. My contention remains the same as it was there in the day one, that it is the crucial date which has to be taken into consideration. And kindly comes back to, my lord, the writ petition and, my lord, the state government affidavit. Kindly sees the affidavit filed by the state government annexing those circulars which we were relying upon. Kindly takes up this affidavit, Mal.
First, tell me the candidates who earlier were in the OBC,
AB.
either A or B,
Yes.
did they have EWS certificate?
We don't know.
Because
They have all applied as OBC A, OBC B.
because that is the certificate which they had at that point of time.
We don't know, maybe. But they didn't apply as EWS category.
I understand.
Yes.
Can
But
a
if they
candidate
have
After
OBC
the
A or
crucial
B,
date, they
they
cannot.
can't have EWS.
Yes.
That's the point.
ABC AB is a OBC.
Because I had matters before me
They cannot have.
They
where
cannot have. That is
where-
only one category.
there.
Your lordship has.
Factually.
14 তারিখের order.
So if that be so,
14 তারিখের order
if
টা-
there is no separate EWS certificate for the OBC A and OBC B category,
Now, my lord,
Sorry to interrupt, my lord. I was under the impression that this had to be taken up on 21st, my lord.
this was mentioned.
this was
And
mentioned, and my lord, they
It was
have given a option for filling up, editing at 20th, on 20th.
tomorrow is the last date.
Tomorrow is the last date.
And it was mentioned, were you not put on notice? Because this is the submission. Where is the notice? Please show. The private parties are here.
Yes, it
They
has been
must have
mentioned.
been put on notice. Please show the notice once to the learned AG. Take your seat, please. Show the notice.
Yes, I am, my lord, my advocate and record has conveniently come. My lord, your lordship, on, my lord, 14th, lordships has been
I
pleased.
get it.
Yes.
So page 28, last paragraph. Can it be worked out? Because
it
the-
cannot be, my lord.
it cannot be.
Because crucial date.
Why are you? No, it's not because of the crucial date.
And this is change of category.
Without even going to that, if the OBC A and OBC B category candidate doesn't possess an EWS certificate, then how can the last paragraph be worked out?
Smaller. And kindly see, একটুখানি ওইটা দিন না, স্টেট গভর্নমেন্টের রিপোর্টটা যেটা দিলাম। May I just kindly excuse me, it is heavily marked.
No, it's all right.
It's,
What
they have annexed the notifications which we have, my lord, relied upon. Kindly sees the annexure, page 10. This is the office memorandum, Ministry of Personnel. Now kindly comes to the marked part, 5.3. Lordship is there. Well, I have marked, kindly, my lord. The officer who issues would do the same after carefully verifying all the documents following the due process and prescribed. The crucial date for submitting income and asset certificate by the candidate may be treated as the closing date for receipt of the application for the post, except in cases where crucial date is fixed otherwise. There has been no fixation of crucial date in the advertisement. Now kindly comes to the page 21. Page 23, paragraph 7 is the income and asset certificate. List of documents is 9. My lord, I forgot where I have marked, my lord. Just can it takes this one? Yes, application procedure. Yes, paragraph 8 is application procedure. There is a specific pro forma. Application procedure, person seeking income and assets shall apply in prescribed pro forma. My lord, that page 23.
23, yes.
Yes. And 24 would be 10.2. Verification of immovable assets like agricultural land, residential plots shall be done by the block land and land reforms officer of Panchayat municipalities, including areas of such and such in KMC areas. This is the procedure which has to be followed prior to the issuance of the OBC certificate. This is a lengthy procedure. And my lord, page 29 is the acknowledgement slip. Page 32 is the memorandum which has been also referred in the notification. Page 32 kindly sees. This 959. Now kindly comes to page 33, clause 7. EWS certificate is valid for a financial year of the issuance of certificate. Here also I have tried to make out a case that they are taking EWS certificates of prior, my lord, period. Now, what is, my lord, very astonishing is that they have annexed only one page. What is that page? Of the FAQ issued by the, my lord, ministry. What is that page? Yes, yes. Advocate, ask.
It's not served. Cannot.
Instruction is
The government pleader was appearing. Government pleader was appearing.
But then who did you serve the notice upon?
And
This is, my lord, the notice, my lord, this really, my lord, if your lordship is pleased to look into this. If this is the cause of urgency.
Yes, 20th is the last date.
What of what? If I may ask myself the question. To make for making, my lord, the online applications we started on 15th of August.
Online application.
That is what I find, my lord. Kindly look into this document.
Page 28, it is 12th of August 2026.
Yes. Now kindly come to the, my lord, towards the bottom of that, my lord, the first paragraph. They should upload their caste certificate by clicking the link to be made available on the website within the period from 14th August to 20th August. So, well, whoever has, if somebody had to make any application or well, had to upload, they have uploaded.
No, 20th August, tomorrow is the last date.
Yes.
And this OBC certificate, EWS certificate, or assuming the OBC certificate, can it be permitted to be uploaded after the crucial date?
That will not, my lord.
Crucial date would be.
Respect, my lord, that will not, my lord, change the nature and character of the petition.
Obviously,
That will not. But then it will open up matters, right?
crucial date was 5th April 2024.
When the process started. When the process started. Now, the moment you give an opening, hundreds and thousands of candidates will come up.
What I am submitting, my lord, if somebody, I could have understood, my lord, that this was, my lord, this point was taken before 14th of August.
This matter was being heard.
From 14th of August.
Matter is being heard.
Till tomorrow is the date within which it can be done.
Last date.
Yes.
My lord, maybe, my lord, I really do
I
not
would have.
know.
Wait.
Should win.
Yes.
Maybe, my lord, that, my lord, this online applications, my lord, or uploading of the caste certificate has been done by many.
Yes.
Maybe.
Yes. Certainly, because it opened on the 14th.
On 14th. So, my lord, there is, in my submission, there is no imminent urgency of, my lord, this matter being taken up today. It has opened and put it. I could have understood that this pilot urgency was pilot demonstrated before 14th pilot, the situation would have been different.
Matter is being heard on day-to-day basis. It has been, well, state government has been directed, man, this is going on for quite some time. The entire process is that.
And
Thing
I
is,
understand
y'all
the
are-
importance of pilot that the entire process shall abide by the result of this.
True, but you know what happens when more number of candidates, they have a legitimate expectation that I have filed, I will get
They
a
will
job.
come.
We are seeing what is happening
Again, this
to
will be
this.
subject to the result of the petition.
Always. That order is always there. But then, I don't know.
My lord, affidavits are here, my lord. Kindly hears it up to date.
Today,
My lord,
As-
Lordship has already heard. Kindly seize the order, my lord. On the last occasion, when your Lordship was sitting in courtroom number 18, Lordship has extensively, entire second up, my lord, we have taken, my lord. Your Lordship has heard me. Lordship was pleased to hear Mr. D.N. Roy and thereafter pass this order. Only for indicating, because I was relying upon circulars of DOPT, the state government was not sure as to whether those circulars have been followed by them. Now it is on affidavit that they have also followed the same circulars. So therefore, my lord, it is, my lord, kindly seize their
today hearing will not be possible.
Act
We are
2, my
at
lord, we have Act 2, my lord,
stage.
we have constable matters. Kindly hear this matter with this. Act 2, your Lordship has fixed these, my lord, Chandandhara matter.
Yes.
Kindly hears with this. Same recruitment process.
Same recruitment.
Same,
process.
kindly hears this matter with that.
All right, 2 o'clock, please come. The one of the other matters is fixed. Even if this is not there, the other one is there.
Kindly seize it.
Our application has not yet been allowed. Either allow or reject.
You stay.
No, no, Kaka, why, Malad? I have take out an application.
And I will show what is
No, no,
his
maybe
application has
let
made
my
my
learned
case
friends-
better.
No, no, your lordship, let my learned friend show.
Your Lordship,
Reject it, but do that. It cannot be kept pending, my lord. Listen, I have taken out an application. Before hearing the petition, that should be hard.
I am hearing all together. দুটো সময় দেবে।
one of the applicant has claimed herself as a general category candidate, subsequently applied for EWS.
এই ফটোকপিটা ফেরত দিয়ে দিন। And whoever your learned friend is, please intimate for this.
Yes, yes.
Give a phone call at least that the matter will be taken up. It's passed over for the time being. It will be taken up.
Well, that was mentioned in the recruitment notification.
What?
That earlier general, then EWS.
That is the
That was
point.
there.
That is the point. After crucial date.
was
Sorry.
there.
I'll hear.
After crucial date.
I'll hear. Yes, item 4.
এইখানে সব রাখবো এখানেই রেখে দিই
My lord, I am appearing for the petition in this matter, my lord.
In item number 4, my lord, I am appearing on behalf of the National Medical Commission.
The other authority, my lord, may I submit the affidavit of service, my lord?
The
My
other
lord,
authority?
the respondent number 2, the University of Health Science, Mr. Chatterjee was appearing for the university, the relevant authority. My lord.
He'll
My lord,
be-
my lord, in this matter, my
My
lord,
lord,
my
if
lord,
I may indicate the facts.
yes, yes, yes.
My lord, if I may indicate the facts, my lord. My lord, the petitioner herein is the final year postgraduate medical student, my lord. She is pursuing her master's in surgery in ENT, my lord. My lord, in order to take that exam, my lord, in this entire 3 years course, my lord, she needs to take only one exam, the final examination, which is held at the end of the 3rd year. My lord, for taking that examination, she needs to submit her thesis, her few certification, and an online course, my lord. My lord, which was not at all mandatory, my lord. There's a notification of 2023 by which that particular course has been made mandatory. But though that particular notification, my lord, which I will place, also shows that time and again certain relaxations were also given, my lord. My lord, because of that, the university has prevented the student to register for the examination, upcoming examination, which is scheduled to commence from 25th, my lord, 25th of August, my lord. The admit card is supposed to be distributed on and from this Friday, my lord, 21st of August. My lord, under certain circumstances, my lord, the petitioner has lost her younger sister who was 24 years old due to cancer. My lord, her mother is also in the final stage of cancer. This happened in while she was undergoing this course, because of which she had taken this exam. My lord, this petitioner has never failed in any subject in any exam. My lord, because of all this prevailing situation, she took her exam.
What is your prayer today?
My lord, let me be allowed to sit for the exam.
And
I
who
don't,
is standing in the way?
my lord, National Medical Commission, and if the university is of the opinion that if the National Medical Commission permits me, my lord, they will allow me to sit the exam. My lord, with an undertaking that my result should be withheld until and unless I pass that exam. That's an online course exam, which is not that related to this course even.
All right,
My-
you show me that this is required to be taken. This
My lord,
6 months course or something online.
my
Where
lord,
is that?
that's one exam which is held in every alternate month. My lord, that is basic course for the course
Please
name
show.
is basic course for biomedical research. My lord, if my lord takes up page number 29. My lord has it.
Yes.
My lord has the notification of 31st May 2023. It says about the clarification regarding eligibility of the final year PG students without completing the online course in research method for appearing in the final PG exam 2023 of the postgraduate program. My lord, a notification was issued in 2019, which my lord will find in the first paragraph. Board of Governors of the Postgraduate in supervision of the Medical Council of India, such and such notice of 2019 has stipulated all PG student admitted from assessment year 2019-2020 onwards shall complete an online course in research methods, which is essential for appearing for the final exam of the respective PG course. My lord, in the second paragraph, further, by such and such notice of 2022, an exemption permitting all PG students admitted in assessment year 2019-2020 who could have completed the online course in research methods to appear in the final examination in 2022. However, the such students have to complete the online course in research method within 6 months, for which Dean will facilitate in registration of the course, and the result of such students will only be declared after completion of the online course. My lord,
Were
here,
you admitted in the academic year, assessment year
my lord,
2019?
not in this academic year. For in the next academic year, I was admitted. My lord, what I am trying to portray is that in earlier situation, even such exemption was given. My lord, in the
Similar
subsequent similar
be
exemption
given to you.
was given for other students even, because this course,
You are praying for similar exemption to
my
be
lord, are
given to
similar.
you.
Yes, my lord.
All right.
My lord, in this next paragraph, Postgraduate Medical Education Board has received the representation from such and such University of Health Science Telangana regarding PG students of 2020-2021 batch, requesting to grant exemption in similar way to permit them to appear in the examinations scheduled to be held in the month of June 2023, as they have not completed the online course in research methods. The students have represented they shall complete the training course within 6 months. Similar representation have been received from the students of 2021 batch from other colleges also. And in the next paragraph, Postgraduate Medical Education Board has decided that all students can be allowed to appear in the postgraduate examination 2020 with the condition that the result will be declared only after passing the basic course. This is a course name, my lord. Basic course in biomedical research. Online course, because 2020-2021 batch was involved in COVID management for 1.5 years, and the course and 2021 batch was admitted in February-March 2022. My lord. My lord, my lord, if my lord takes up my prayer, my lord, once, which appears on page number, my lord, 2024. My lord, I am seeking the petitioner should be allowed to sit for the forthcoming final examination. My lord, I am willing to give an undertaking that she should be allowed to appear. And my lord, this examination, this BCBR examination is next scheduled to be held on 27th of September. My lord, by them, the result will also not be published for this main examination. My lord, if I pass that examination, I will submit my passing certificate to the university and the National Medical Commission. Then only my result will be. I am simply asking for a permission to appear for the examination, my lord.
My lord, regarding this regulation, National Medical Commission, my lord, published one regulation that is called, my lord, Postgraduate Medical Education Regulation 2023. It is, my lord, gazetted on, my lord, 29th of December 2023. After, my lord, the new act of 2019, the National Medical Commission Act, my lord, has been enacted, repealing the Indian Medical Council Act 1956. My learned friend shows a document that states that 2019 facts regarding 2019, that the particular course is made mandatory, that is made by the earlier Medical Council of India. Subsequently, the course entire act has been repealed by the new act, National Medical Commission Act 2019. My junior is there, my lord. He will hand up the relevant portion of this regulation.
অনলাইন দাও
My lord, kindly turns to chapter 5,
এটা কে দিচ্ছ
page 33. Chapter 5.
কলেজ মিনিটস
সেটা তো পাচ্ছি না কিছু চ্যাপ্টার
Period of training. Then, my lord, kindly turns to the next page, page 34. Page 34, Roman 11. Course in research methodology, my lord. All the postgraduate students shall complete with an online course of research methodology. The students shall have to register on the portal of the designated training institute. The students expected to complete the course in the first year. The online certificate generated on successful completion of the course and the examination thereafter will be acceptable for evidence of completed the course. The above certification shall be mandatory requirement to be eligible to appear for the final examination of the respective postgraduate course. It is mandate. This mandate was imposed by the National Medical Commission by this regulation of 2023. And with respect to my lord, notification relaxing the condition, my lord, I would like to submit those relaxation, my lord, one-time batch specific relaxation, because of the fact in the COVID-19 pandemic, all the resident MD, MA students has been, my lord, delegated to their my lord, critical care unit, and so they have not able to complete their online research course. Therefore, this one-time relaxation was granted by the National Medical Commission for the entire country, not only for one particular student, my lord. This relaxation was extended for the total throughout the India. And similar type of matter, one matter was moved before the Kerala High Court, my lord. My junior is there, my lord. He will hand up a judgment passed by the Kerala High Court. My lord, in this matter, page 4, para 4, I am reading, my lord. The prayer sought by the petitioner grant of exception to the petitioner from requirement of completing the BCBR online program attending the final examination in the MD course, rightly pointed out by the learned standing council as per the annexure 2A, R2A. The same is mandatory requirement, and the students had to complete the same during the first year itself. However, it is submitted by the learned standing council also arrived in the counter affidavit that the students who are undergoing MD examination in the year 2019 were permitted to set course in the year 2022, and even the students were granted exemption for the final examination in the year 2022 as well. It is further pointed out that in the year 2023 also, the exemption was granted by the National Medical Commission. It is an admitted fact that the petitioner availed the said opportunity in the year 2022, but could not succeed. And as for the opportunity provided in the year 2023 concerned, he did not avail the same. Thus, it is evident that the petitioner was granted ample opportunity to attend the examination by granting exemption, but could not utilize the same. Therefore, I do not find any justifiable reasons to grant further opportunity to the petitioner. Moreover, since the matter which is applicable to all the students, the exemption to the petitioner alone cannot be granted. If this judgment provides the exemption, when NMC will grant the exemption, it's for the all throughout its applicability over the throughout India, my lord. It cannot be restricted for a particular students. And my lord, here my lord, petitioner in this matter also, petitioner appeared in last year, my lord, BCBR program. And my lord, he has, my lord, if your lordship kindly turns to page 30. That is the last year he participated in the particular exam, but he has failed. She has failed, my lord. Now she is taken a point issue that my mother is she is a cancer patient. I have lost my daughter, my lord, sorry, sister, my lord. For that reasons, my lord, a blanket, my lord, relaxation cannot be issued by the NMC by, my lord, without my lord, disobeying their own regulation of 2023, my lord.
All right.
Milord, may I respond subject to correction? Milord, first of all, the distinguishable features in the judgment which my learned esteemed friend has referred, there was an opportunity.
First, should
No.
go to the
Yes.
this regulation.
Regulation, Milord. The copy has not been handed over to us, Milord.
It is available to the.
Wait.
No.
You, according
yes.
to this regulation, you are appearing in the
Yes.
examination.
Number one, Milord, I said, Milord, that I relied on 31st May 2023. Milord, Mr. Rai said just now that this was, Milord, in a case of a COVID situation and there was a general extension, special circumstances. Now, this regulation, Milord, this is a notice, only a mere notice issued by, Milord, the President Postgraduate Educational Board, National Medical Commission.
Page 29.
Page 29 is a notice, only
But
notice.
this regulation, check up the
Regulation, yes.
It's the postgraduate checkup from your phone.
Yes, Milord.
Postgraduate Medical Education Regulations 2023.
Yes.
And it specifically mentions it has to be done in the first year and it's mandatory.
Milord, there was, Milord, in this case, I did not get any opportunity, Milord. The last year I appeared, I said, Milord, I omitted. In this case, Milord, the Kerala, Milord, I have only two judgments, Milord. There are 3 points, Milord, subject to correction. One is, Milord, if your lordship allows an individual, there will be a floodgate. That is a normal, Milord, submission makes. Second, Milord, that why this sympathy should be allowed, Milord, because this is unknown to law. To that, I will rely on another judgment of the Supreme Court. And third, Milord, that this notice, the regulation, Milord, it is said it is mandatory, no doubt about it. But, Milord, by virtue of this notice, after 2 years from the date of COVID, this was relaxed, Milord, after the promulgation of the new regulation.
No.
Before that.
Yes.
Before that. But question is under the same spirit, because he said, Milord, Medical Council Act. I will say, Milord, 2 judgments. देखिए कोई judgment দে যেটা 2019 না যেটা বললাম যে sympathy নিয়ে যেটা হচ্ছে Milord, in similar circumstances, Milord, not, but though, Milord, the court did not, Justice Basu, Milord, his lordship then was, has, Milord, passed a judgment. এটা জজসাহেবকে দিন তো, আমি এটা আনরিপোর্টেড দিচ্ছি আমি।
সাইটেশনটা বলো না, মানে নাম্বারটা বলো, বলুন দা।
Milord, kindly see. Milord, this is, Milord, a case where, Milord, the provisional, that Milord, the petitioner had participated. I start reading from, Milord, page 2. Participated in the said entrance test through under OBC category without taking benefit of the reservation on the strength of merit. He was allotted a seat under such and such. The admission procedure in the allotted seat requires to be completed between such and such period. On November 17, a provisional allotment letter in favor of the petitioner was uploaded in the West Bengal Medical Council. He had downloaded, Milord, the said allotment letter on November such and such. Then, Milord, ultimately, the father of the petitioner had planned that he would pay rupees 15 lakhs out of the total college fees of 25 lakhs, and to pay the rest shall take the benefit of the student credit card. Accordingly, he had handed over 2 checks of the said amount of rupees 15 lakhs to the petitioner. Then, my lord, November 2025 had started for Kolkata after a overnight journey reached to college on November 20 such and such, which was the last scheduled date for admission. The petitioner on reaching college came to learn that in order to complete the procedure, he is required to deposit the course fees in the designated department at such and such. I just came. Now, my lord, kindly see this judgment, paragraph 10. This was also amended. The Honorable Supreme Court in case of such and such reported in such and such has observed inter alia that a meritorious candidate student who has been denied an admission in course illegally or illegally by their authorities for no fault of his heart, who has approached this court in time so as to see that such meritorious candidate may not have to suffer for no fault of his or her. In the present case, the provisional allotment is completely silent about the mode and payment of course fees. A student coming for the first time in the city Kolkata who had approached a college to get admission in his allotted seat was asked to move another place to complete the admission procedure and reaching the said place. Then, my lord, the court had, my lord, this is the point, my lord, which I want to urge for your lordship's kind consideration. Dr. Prem Kumari versus Divisional Commissioner Mysore and others reported in 2009-12 SCC page 267. The law is merciless is a most frequently quoted saying. It has led people to mistakenly think that it is separated from feelings or righteousness. We have become used to understanding that such emotions as indignation, sorrow, and compassion should not exist in the legal cases, especially not in judiciary. This, in our view, is misunderstanding. Judiciary has a strong sense of justice and it works to maintain social justice and fairness. We hasten to add that judiciary does not believe in misplaced sympathy. Now, my reason is, my lord, that there is no proved negligence on my part. A situation beyond my circumstances, my lord, my feelings for my family, my lord, I have lost, my lord, one of my dearest kith and kin, and I am the daughter. I had to take care of this. Such situation is beyond control. Whether this omission is negligence, for which I have to, my lord, take these sufferings on my shoulder. If this omission, because all failures are not seen, my lord, subject to correction, if this is the understanding of the Honorable Supreme Court in Prem Kumari, my lord, that, my lord, whether I cannot say today at the end of the day that this statute is not mandatory. But question is, he said just now, for this only, my lord, I cannot be granted any benefit. I said I am giving undertaking. I said, my lord, that unless and until the university does not, my lord, maintain any system of taking, my lord, the semester, there was no intimation. I, my lord, missed the bus, only one. Kerala case, my lord, multiple opportunity was there. Question third, my lord, subject to correction, false for my lord's consideration. What is the stand of prejudice, my lord, to be suffered? Today, the court is not flooded with any claims of any of the citizen, my lord, from the state of West Bengal, that in such a situation, my lord, that someone has come. Now, the court has also read down the law in such a situation. Many a times, your lordship says it will open the floodgate. Many a times, we are confronted with this submission. The Supreme Court said, my lord, in Coal India Limited and others versus Saraj Kumar Mishra, 2007, 9 SCC, page 625. It Joseph Khede bani paragraph. Chapter to tolai kar. 2007, 9 SCC ta. যেটা বার করলাম সেদিন ওইটা দর্শক কেন আপনিও যেটা দিলেন এটা জজসাহেবকে দিয়ে এটা দিয়ে দিন 2007 9 SCC 625 Millard 19 paragraph, Millard, subject to correction. The floodgate argument also does not appeal to us. The same appears to be an argument of desperation. Only because there is a possibility of floodgate litigation, a valuable right of a citizen cannot be permitted to be taken away. The court is bound to determine respective rights of the parties. Now, Millard, question here is, Millard, that floodgate, Millard, is a proposition. Now, the court, Millard, under these circumstances, Millard, when, Millard, there is no negligence, whether it amounts to fault, Millard, such omission. If court determines, Millard, there is an omission, whether, Millard, the court taking recourse to Prem Kumari, Millard, page 267, Millard, whether court can say that this sympathy, otherwise, Millard, if I have to confront this idea that COVID is an epidemic and that is why the entire country was plunged into deep crisis and the government has formulated policy, medical commission has aroused. This regulation, whether in such a circumstances, Millard, can be, Millard, relaxed or the authority can consider this, because my lord, it is a student's life, and my lord, she is a meritorious student. She has, my lord, only this chance, whether, my lord, otherwise, my
Why
lord,
only this chance? She will not get a chance to
no, my
complete
lord, this chance, my lord, will
graduation
complete, my
tuition.
lord, no, my lord, 3-year course, and my lord, 6 semesters only, my lord. I have only, my lord, this is a, they said, my lord, they 2023, I have taken the admission. This
Yes.
regulation came into being on and from 23. I
Yes.
only say, my lord, that the day, my lord, this relaxation was made, whether it is question of 1 or 1,000, in case of 1, my lord, whether this situation was beyond my control, whether, my lord, the authority can consider this, my lord. Only this. And when there is a very clear undertaking that I will not ask for any equity unless and until I clear, because your lordship is not invited to, my lord, grant exemption. Elasticity of a rule, my lord, without breaking the same, only the expansion, my lord, whether, my lord, it is, my lord, it comes within, my lord, a court's discretion informed by reason and exercising its equitable jurisdiction. I, my lord, I have not come with an unclean hands. I said, my lord, it is a fault. Fault means omission. Whether such omission, my lord, can be read, my lord, explained, interpreted, that yes, the rule, I am not asking the court, my lord, to bend the rule. My lord, by elasticity, the elasticity, the rule, my lord, applies here, my lord, whether this form of elasticity, my lord, whether it, my lord, demolishes the edifice of the entire administration or stand of prejudice.
According to the rule, you had to clear the examination in the first year itself. You are there in the third year. Why?
I'm third year.
Why? Why?
My
From
lord,
the
there was no information. No.
information. The
The,
letter
the, the,
is there.
the university did not, my lord, kindly ask the university to file a report whether the all students, my lord, have cleared. Kindly ask the university to file a report if I am an exception, because I have my specific instruction. There is no such instruction. No implementation. My lord, many a times in our college days, my lord, the college receives instruction from the university. It notice board, my lord, we came to know about that. Then, my lord, the decision is implemented. If there is a climate of ignorance which is deep and all pervasive, I fell victim, my lord. I was a victim. Rule says, I am not disputing, my lord. There is no quarrel about the, my lord, the sanctity of the rule, the correctness of the rule, my lord, the existence of the rule. But even then, question comes at the end of the day, my lord, whether the rule was implemented religiously. It's a student's life, my lord.
What student's life? If
1 year.
candidate, yes, it's a matter of 1 year. The
My lord,
student is
no.
a teacher.
No,
Is a
seniority.
medical,
My lord,
medical.
this senior residency, everything, my lord, will go. Kindly ask the university whether they have at all implemented for the last 2 years. Kindly, my lord, ask for a report. I'm not mind. I will not mind. Kindly ask them to file a report, my lord, in the form of affidavit. 1 page report. 1 page report. Whether this regulation.
I am behalf of the college, and we have, as per Annexure 9, page number 54,
number
we have
54.
College also made a request.
we have made a request to the NMC to grant to the student sitting chance.
Only one student.
One student.
No others.
No others.
Everybody appeared in the examination.
Everybody appeared in the exam.
Yes.
This
Appeared and my lord, they have passed, qualified.
Everybody has qualified.
didn't qualified.
But
in
Maybe
this
the student will also qualify, but it's only a matter
yes,
of
yes.
time.
It's a matter of
And
time.
there's a last sentence saying that there is a lot of procedure after if any student pass one first chance. In that case, he'll get lot of opportunity. Otherwise, he will deprive from hindrance from every sector, from
First
job,
chance in
first
PG. In the PG.
PG, MBBS, everywhere.
All right.
If he complete his course in first chance,
I
then
will not
he
get any
lot of
preferences super
opportunity.
specialty
If it's,
hospital.
second chance, he'll get lot of
Course.
hindrance for job opportunity, higher education, everywhere. That's why he's saying it is the last chance. But because if he is complete this MS course in first chance, then she will get a lot of
Better opportunities.
many
to-
opportunity in her life.
Yes.
My lord, it
And,
will.
she is meritorious student. That's why we are
Anyway, my lord, anyway, after completion of a course, he has to, my lord, render 3 years complementary service to the state.
No,
I will
that
do
is
this.
different.
That is different.
That is different. That is not the
Yeah.
issue.
Yes.
Whether
And
she
another thing, my lord,
passes it in the first chance or she waits for another year to pass the examination. Is there
Yes, yes.
scope for any relaxation?
no, my lord, there is no scope
They
for
will not do this,
relaxation,
my
my lord.
They
And
will
the
not.
judgment relied by my learned senior, Mr. Basu, my lord. My lord, probably, my lord, in that matter, I was there, my lord. Before
Which matter?
Honorable Justice Basu, my lord.
Sir,
This judgment.
Forget about
today,
Justice Basu,
uh,
Supreme Court I am saying. Forget
that
about
was
Justice
passed
Basu's judgment.
relying a judgment of the Honorable Supreme Court in A.S. Krishna Sarda, where, my lord, the Supreme Court says, my lord, for the no fault on the part of the students, a students cannot be made suffer. My lord, in that particular case, a PWD candidate was deprived.
I
Subsequently,
understand that.
and another thing, my lord, I want to, my lord, rely, my lord, if your lordships kindly turns to, my lord, one representation, page 52, before the controller of examination.
Yes,
52, 52.
yes.
My lord, I am only reading, my lord, para 2, second paragraph. At present, I am unable to fulfill the required BCBR eligibility certification, and consequently, I am facing difficulty in completing my examination registration. I sincerely regret that I could not identify and rectify this issue earlier, as my mother suffering from cancer and undergoing a surgery of chemotherapy. I acknowledge this oversight and take full responsibility for it.
Yes,
He
very
has
honest
taken her
confession.
full responsibility.
In the next paragraph, kindly ask him to read the whole
Mr.
paragraph.
Basu submitted that it is not, there is no fault from her part. He herself admitted.
Milord, I extremely grateful to him because he said my mother is suffering from cancer. I lost my Milord
Yes.
sister, and I will dance delightfully, ignoring all these things, and will go for the
She
examination.
could have
So
completed
I
this
do not have any
examination for the
responsibility
first
to my
year or
family.
second year.
Fault means
Could
what
have
is that? I
completed
said,
this
no, Milord, I
online
said whether
examination.
I'm negligent,
She could have taken
whether my omission
this
is amounts
particular
to
regulation
negligence.
provides her 3 years,
Negligence.
3
Whether my
consecutive
omission.
years.
University
He
does
had
not.
not
University is not
participated
in
in
a
the first
position to
year
show
of
to your
MD course,
lordship.
second year of the MD course, second year he participated and
I
failed.
said this was never followed. Let him.
And
Let him.
this is the last
file a-
year, third year. Now he is, my lord, praying before your lordships
Please.
that kindly permit me to participate in the final MD MS postgraduate medical education examination without adhering the regulation of 2023. That is the mandate of the 2023 regulation. Is BCBR course is mandatory prior to appearing in the final examination.
I said, my lord, that this rule will not be broken if the examination which I wish to sit for, my lord, that it will be suspended till I clear. I said, my lord, that is
And they
within
have
the
not
scope.
challenged the 2023
No, why should I?
regulation also, my lord.
It is a matter of policy. It is a matter of policy. I did not challenge. I cannot deny this fact. This rule was never implemented, my lord, for the last 2 years. My specific instruction, my lord, Mr. Rai, my lord, my respected friend, my lord, did not utter a single sentence that the cause of prejudice. Whether it is such a heinous thing, my lord, which I am praying before the court, that if the court allows my prayer, whether the entire administrative fulcrum will be destroyed. I don't seek any indulgence, my lord, only compassion and empathy, my lord, which is also a foundation, my lord, of this justice system, delivery system, which Supreme Court has acknowledged. Court, my lord, is managed and run through the human agency.
When is the last day you say? Tomorrow?
কবে রে? হ্যাঁ?
21st for admit card.
বল না, মাসটা বল না।
21 August.
21st August।
Yes, Friday I
For
see.
admit card. Exam on
Very well.
6 তারিখ।
Had submission made on behalf of both the parties. List the matter tomorrow for orders.
Deeply obliged.
Service is taken on record.
Obliged.
Lordship, Mr. Bari is appearing virtually, Lordship, for the petitioner.
For the petitioner, Malat, I want to do it Malat, physically tomorrow. Malat, kindly, Malat, I am in circuit bench today. Malat, kindly take it tomorrow. Malat, I shall do it physically.
Accommodation has been sought for by the learned advocate representing the petitioner. Let the matter stand urgent for this week.
Malat, I will do it tomorrow. Malat, kindly, Malat, kindly, Malat. I will do it tomorrow.
It will not be possible. I have fixed up other matters. Please come next week. Yes, next.
Very well.
6.
Not after the
My lord, I am appearing on behalf of the Central School Service Commission.
Lordship, I am appearing on behalf of the state in this matter.
But here it is a matter of a transfer of the school teacher. So, my lord, the previous one, there were two different rounds of litigation. Initially, my lord, challenging the rejection of the transfer order on the ground of, my lord, lower pupil teacher ratio. My lord came before this honorable court. The honorable single bench dismissed my writ petition. I went before the honorable division bench. Honorable division bench set aside the order of the honorable single bench and directed to file another offline application after which, my lord, I have done. So in this meantime, they have just taken the school this time, my lord, has forwarded my case to the district inspector. The district inspector rejected my case on a my lord, point
Your ground of transfer is?
distance. So, my lord, on a point, my lord, that rationalization policy does not permit me for getting the transfer. But I have got, my lord, the policies, my lord, print out. That particular policy will not even be applicable in these cases. But that policy is only applicable in case of surplus teachers. So, my lord, here I will be guided by the transfer rules. My lord, they could have, my lord, considered my prayer, my lord, pursuant to the rule of 2015, or, my lord, the amendment or whatever is there for the timing in force. My lord, if I just could take your lordship, my lord,
Show
take
the
order of
rejection,
rejection.
please.
Yes. It starts from page number 41. If I request your lordship to directly come to page number 45, the operative part. My lord, if I could just, my lord,
Page 41.
41 starts. My lord,
Yes.
if I just could take your lordship directly to page number 45, the operative part, the reason that has been stated.
Yes.
There, the entire rules are quoted in the order. This is why it is so long. So, as per available records, class-wise students' enrollment in the school of such and such, where the petition is working, is following: class 5 such and such, 6 such and such, and such and such. Total enrollment from 5 to 10 is 2282. Total sanctions post of teachers in the school is 53. Total number of teachers in position is 25, and number of vacant posts is 28. Therefore, in the normal section, the PTR in the school, pupil teacher ratio in the school, is 91.28 each to 1. Well, let us say 92.1. So obviously, as per the Right to Education Act, the school is not
At all
it's not
surplus
a
teachers.
surplus teacher school. It does not even arise. It is also found that there exist only 2 teachers in the subject of geography in the school out of 5 sanctioned posts. On transfer of the application, existing geography teacher in the school will be 1. So at present, for the subject geography, the school is not at all a surplus school teacher school. Moreover, the petitioner is not a new incumbent in comparison to his date of appointment in the concerned school. Well, this is the policy of this rationalization. There are many assistant teachers in the same school who are junior to him in comparison to the date of appointment. Therefore, the serial number 2 of 10th of February 2023, the rationalization policy, does not allow the petitioner for reallocation from her present school to place him to another school. So the such and such of 10th of February surplus this rationalization policy does not allow any own seeking transfer having adverse subject or group subject PTR. Therefore, in terms of 10th of February 2023, at present, there is no scope to allocate any assistant teacher from such and such to any other school. So hence, in pursuant to this order of the Honorable Division Bench, and the aforesaid transfer application of the petition are taken for consideration, but under circumstances stated in accordance with the existing government such and such, is hardly any scope to provide him any relief. So if I just could say, my lord, what they are trying to mean here, my lord, this government order
10th February, just show
Yes.
once.
This 10th of February 2023, my lord, is the notification of the government of West Bengal of, my lord, rationalization policy. So it basically says in these schools where there are surplus teachers, more than teachers which are required to be there as per the Right to Free and Compulsory Education Act, those teachers who are newly engaged, he will be, my lord, put to a school where, my lord, there are low PTR. So it is rather the opposite of what the transfer on seeking rule is concerned.
And that is under administrative transfer, my lord. 10B.
Yes, absolutely right.
Thank you, sir.
Please come to the last clause 7B.
Yes. Yes. The state government, keeping the situation in mind, also decided to take long-term measures to protect the school from being teacherless as follows. Teacherless as follows. The school education department, education directorate.
Go to that B.
No application for own seeking transfer shall be allowed from the school having adverse subject PTR. Transfer rules have already been amended accordingly. All concerned officers relating to the transfer process shall follow the same. Yes, my lord. This is with respect to the adverse PTR schools, means my lord, the schools who are having, my lord, the surplus teachers
No, not surplus, deficit at the same time.
at the same time.
Right.
Then, my lord, kindly sees the next line. Transfer rules have already been amended accordingly.
I understand.
And
Because
this is a notification.
even single subject teachers can be transferred. This is what the law says.
Yes.
So
This
the
is what I was trying to just take your lordship.
rejection may not be proper.
Yes.
But then
So I just request your lordship, my lord, lordship, I have already seen this amendment of 2021, which is, my lord, guiding our transfer on our own seeking. So there, your lordship, my lord, there are two situations that have been enumerated, which your lordship has seen thousands of times. If I just could request your lordship once again to see once, which is, my lord, annexed as page number, it starts from page number 60. And, my lord, the relevant your lordship will see at page number 61.
yes.
61, my lord, 6(2)(c). May I please, my lord? Consider the number of subject teacher and roll strength. If resultant vacancy of the school in particular subject becomes 0 or not commensurate with the roll strength, the authority of the school managing committee shall not forward the application. So this is the embargo, my lord, that was introduced in the 2021 rule. Thereafter, my lord, the relaxation was done by the 3rd January amendment. That your lordship has seen number of times. It is also annexed at page number 66.
Yes.
At page number 66, your lordship will see that 3rd January notification, my lord. It says that whereas 6(2)(c) of the general term and such states that the schools shall consider the number of the subject teacher and roll strength. If resultant vacancy of the school is particular subject becomes 0 or not commensurate with roll strength, the authority of the school managing committee shall not forward this transfer application. However, it will not be applicable to single subject teacher or post for which state government will issue separate guidelines. And whereas it is observed
that a considerable numbers of teachers, particularly in higher secondary section where a single teacher is available to teach particular subject, are not able to get opportunity for transfer through Utshashri portal. In some cases, such teachers are in dire need of transfer but failure due to such provision. Now, after examination on the issue in terms of the proviso to Rule 62C of such and such rules of 2015, following guidelines are issued to take care of the transfer application on the above referred teachers. In the event of teacher makes an application for transfer, the school managing committee will not reject the application and will inform the DI about such application. The DI will immediately discuss the matter with the school education department, the commission of the school education. In fit cases, the district inspector will take urgent step in time-bound manner to search for a teacher on same subject for nearby schools and make local arrangements so that the teacher of the other school attends the school where from the teacher concerned has applied for transfer on limited days of the week on a temporary basis till such time a permanent teacher on the subject is joins. The DIAC will inform such arrangement of the Commissioner of School Education, who shall inform the matter to the chairman and president of the WB West Bengal Board of Secondary Education and the School Education Department. CSU will ensure such arrangement in 7 days time immediately. So, all I was just trying to say, to relax this position, that if someone is a single teacher or someone is a teacher of a school having an adverse PTR, in that event, which is not at the fault of that particular gentleman. So, this is why the school education department has come up with this. So, once they have specifically said about the single teacher, the same benefit, more ought to have been given to the persons where there are more than one teacher. There are more than 2 teachers or 3 teachers. So, my respectful submission before your lordship, the law, subject to your lordship correction, the law, cannot be read that in one particular school where there are 300 students and 1 teacher, he will get the benefit of this particular notification. But where there are 300 students and there are 2 teachers, neither of them will get the benefit of this notification. So, my respectful submission before your lordship here at the problem that we are having in hand, which is at page number 45. There, they have applied the policy of rationalization, which is applicable to the cases where, the surplus, where the teachers are in excess. So that is a non-application of mine. So my respectful submission before your lordship, that my case, the analogy that your lordship has drawn in several matters in the honorable division benches as well as by this honorable courts, that this policy will let them search for the arrangement. If that could not be found, in that event, my case could be forwarded and thereafter the vacancy could be feed up. This is my respectful submission.
Lordship, I shall come back with instructions, or if Lordship directs me to file the report, I shall do the same.
No, there is no question of filing a report. It's a point of law that is being argued. No instruction also required. Are you aware of the notifications which your learned senior friend has referred to?
Lordship, I'm aware, but still that I've just received this. I've just received instructions to appeal this matter. In some time to come back with the same.
This provision to for appeal before the Commissioner of School Education remains.
Yes. And as my learned senior Mr. Roy for the commission has rightly pointed out, this particular rationalization policy is with respect to 10C.
Oh, that's all right.
Not with respect to 10B. But if they could once again revisit after this particular order, anyways cannot stand, subject to lordship correction.
There is another notification, of 3rd January 10 AC. It is also in the page 66 regarding 10%. It's dealt with where in a school, if the teaching strength is less than 5 or 5, what will be the fate?
Right. Not applicable in my case.
See, the State Council, I'm minded to set this aside, but I would like to give you one opportunity to go through it and come back. Right?
Your Lordship.
Check up the notifications which are annexed to the writ petition and the judgments. Even if there is one teacher, a single teacher in the school, his or her transfer application cannot be kept pending. So relying on this analogy also, you cannot reject. Do you get it? So this requires to be set aside, but I will give you one chance. You please go through it and come back.
Madam.
I keep it next Wednesday. Please come.
Your Lordship. Grateful. Madam.
The order of the District Inspector of Schools, Secondary Education, Malda, dated 13th January 2026, rejecting the petitioner's application seeking transfer, is impugned in the instant writ petition. Stop. Learned advocate for the petitioner has advanced submission and has relied upon the notification dated 10th February 2023, relied upon by the District Inspector of Schools to reject his prayer, and submits that the said notification cannot be made applicable in the facts and circumstances of the instant case. Stop. Prayer has been made to set aside the impugned order of rejection. Stop. Paragraph. Learned advocate representing the state respondents seeks time to come prepared. Stop. Next. In view of such submission, release the matter for further consideration on 26th August.
Grateful. Grateful. The affidavit of service will not be taken.
Yes.
The new one.
Grateful, Lordship.
That it is an offline transfer application on medical ground. However, medical issue of the petitioner has cured. Only playing let the petitioner be liberty to apply in online platform.
The petitioner seeks transfer. Stop. The online Uchshasri portal is currently functional. Stop. Next, in view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to apply in the prescribed format in the Uchshasri portal. Stop. If such application is made, the same shall be considered by the authority in accordance with law. Disposed.
Great.
Page 45
Yes.
is the rejection by the school. My lord had directed that the application was pending in school sent. Page 45 is the rejection.
Who are you representing?
Ma'am, I'm appearing for the state. I'm led by my senior Sudipa Bhattacharya. It does.
Anybody for the school?
No, school didn't even contest the first round, which my lord disposed of.
Please come. What is your submission?
My lord, it has come to our notice that we have been engaged in this brief, but we haven't got any documents. It shows from the registrar that we are in this matter. But
the moment you see it in the register means that copy has been served.
Yeah, but we have.
Do not use these type of expressions in court.
Sorry.
Are you in the panel?
No, I'm led by my senior Sudipa Bhattacharya.
Please bring your senior. Call your senior. I'm passing it over for the time being. Call him. Yes, next. Yes, 9.
Item number 9, my lord. my lord, in the meanwhile, my lord, the petitioner already applied in the Ushosri, so nothing remains in the
All right.
matter. So my lord might be
The
disposed of.
petitioner seeks transfer. Stop. The petitioner has now during pendency of the instant writ petition, comma, the petitioner has already applied in the Uchosri portal. Stop. Paragraph. And has that been considered?
So not yet considered, my lord. So my lord,
Immediately
kindly
considered.
one line maybe.
The instant application stands disposed of with the observation that the application of the petitioner filed in the Uchosri portal shall be considered in accordance with law. Disposed.
Good.
Next.
My lord, item number 10, I am appearing on behalf of the petitioner, my lord. Affidavit of service, my lord, kept on record, my lord.
Yes.
My lord, in pursuance of court order, my lord, a reason order passed by the authority, my lord.
Which authority?
SSC. My lord, the reason order is annexed here in page number 115. Before that, my lord, kindly turn page number 112. My lord, that is the order, court order. In pursuance of that, my lord, I just read page number 113, the last portion. In view of the submission made on behalf of the parties, the petition stand disposed of by directing the chairman, West Bengal Central School Service Commission, being respondent number 5, to take decision on transfer application of the petitioner by 8 weeks from the date of communication of this order.
It has been said that there is no vacancy.
Vacancy. Now kindly turn, my lord, very next page number 116.
Yes.
Why this reason order is not in accordance with law, and not only that, my lord, because through this letter, my lord, I reflected that there is some discrepancy also. May I read, my lord, slowly that representation, which is very important, my lord. From the petitioner to the secretary, West Bengal Central School Service Commission. Respected sir, with reference to the above mentioned letter vitae memo number such and such, that means the earlier pages, the reason order, you have communicated to me the decision of my transfer application in view of the solemn order dated such and such, that according to your said letter, my rank is 3 in my first preferred school, namely Balurghat Lolit Mohan Adarsha Uchcho Vidyalaya, and no vacancy is seen in the portal for my second and third preferred school, namely Boromwali Lakshmi Pratap High School and Balurghat Jaichand Lal Pragati Vidya Chakra, that my transfer application has been forwarded finally to the WBSSC by the DI of school Dakshin Dinajpur on last 31st January 2022. As per the notification video number such and such of School Education Department such and such, I just skip it. The commission failed to consider my case within 3 weeks from that receipt of the transfer case. So there is a stipulated time, 3 weeks. They failed to do so from the concerned DI school, but the commission issued recommendation letter in favor of other candidate for the other 2 preferred school, namely such and such and such and such, within February 2022. Because they not forwarded my transfer within 3 weeks, that's why my lord, other candidate, they got opportunity, because which is very important, because I am a headmaster, my lord. Usually in my post, my lord, the transfer application is very limited, my lord. For that reason, I challenged it, my lord. That in the meantime, all the HM who had applied for general transfer on last August 2021 under Balurghat subdivision has joined to their preferred school within February 2022. But the vacancy of HM of Balurghat Lolit Mohan Adarsha Uchcho Vidyalaya remains vacant for an unknown reason.
See, all these dates are of the year 2022.
Yes, my lord.
21.
Because that is
Now-
in pursuance of, my lord, because why this is important, very important, my lord, each and everything, because of that, my lord, that also in Ushosri portal, that discrepancy if remains in Ushosri portal, my lord, because of that headmaster post, the transfer application which is considered, that is very limited. It is not a subject teacher.
I understand, but then time is long over. See, we are in 26. What is
Yes.
to be done in 2022?
My lord, may I request, may I pray one thing, my lord?
Where
Yes,
is
my
the
lord.
state? Where is the state? Did you serve?
Yes.
Fresh notice issued? Fresh notice.
issued. Fresh notice, my lord. As per there is no such instruction, my lord. It is served recently as per
It was the earlier notice possibly and fresh notice.
my lord, 4th May 2026, my lord, on that day.
So one
That's
notice
helpful
to
day.
be given. Let us see where there are
My lord,
vacancies.
may I request two things because of that, my lord. In the meanwhile, my lord, I applied it. But
Uchosri again.
my lord, but my instruction is that because it is not limited to that, because limited post is there. So if that is something discrepancy happened in that process, so whosoever the beneficiary of that process, I made them party. Let's SSC in pursuance of my recent representation, that is which is annexed in my representation page number 116. Let's they consider it and bring instruction whether the others they are the beneficiary of some discrepancy or not. If they are the beneficiary, I made them party. Thereafter, if required, my lord, kindly substitute them with me, my lord. Because that's my prayer, because the headmaster seats is very limited, my lord. If
In every school, there is a post of headmaster is vacant.
because one post, single post, and that is
Every
not that.
school, most of the
Obviously,
school
but
in
they
the
are not.
state of West Bengal has been run by the TIC.
But
What
every
Mr. Sami is
post is
submitting.
not vacant. Every headmaster post is not vacant. So limited
And an issue
headmaster
of
post is vacant.
2021.
So that's why if there's something wrong happened in the 2021, that's why I challenge it.
Reason order passed in 2025.
And reason order when the reason order passed, my lord, kindly turn page number 115. The reason order passed 2025. So whenever the reason order passed, immediately I made the representation. What the discrepancy is there, they are not yet considered. Considered my representation, whether there is a discrepancy or not, bring the instruction and made them party. I will make them party if they are the beneficiary of the discrepancy, posted out.
Then, my lord, kindly direct the commission to consider the representation dated, my lord, 7th of April 2025.
Please come. The petitioner's application seeking transfer stood rejected by the commission on 20th March 2025 on the ground that the 3 preferred school applied for transfer by the petitioner does not have any vacancy. Stop paragraph. The petitioner, disputing the reason and the ground for rejection, immediately filed an objection before the commission on 7th April 2025.
And 13 May, very next page number 120, 13 May 2025.
Followed by a reminder on 13th of May 2025, specifically mentioning that there were vacancies, but vacancies in the schools where the petitioner had applied. But as the application of the petitioner was kept pending beyond the stipulated period of 3 weeks, accordingly, the applicants who filed application after that of the petitioner stood allowed. Stop paragraph. There is no response to the objection lodged by the petitioner. Stop paragraph. Submission is that the petitioner is serving in the post of headmaster, where the number of vacancies is extremely limited. Prayer has been made to direct the commission to revert with the response to the objection filed by the petitioner. Stop paragraph. The The commission is directed to file a report on affidavit. Upon consideration of the petitioner's representations dated, dates of which are mentioned herein above. By 18th of September 2026. Release the matter on 28th of September 2026. Stop paragraph. Let copy of the cause papers be served in the office of the learned government pleader. Stop. Learned advocate representing the state respondents shall obtain instruction with regard to the vacancy of the schools. Do you have any other school where you want to apply or anything of that sort?
No, my lord, that is not because of that vacancy is very limited. That's the main endeavor.
State
But my
Council
instruction
of
is that,
instruction on the
my lord,
adjournment.
my instruction is that whether it is still vacant or not, my senior says it is written in the representation that first paper school still vacant. And another thing is that, my lord, kindly, my lord, the second last paragraph.
When it first preferred school is Balurghat Lolit Mohan Adarsha
Yes,
Ucha
yes,
Vidyalaya.
yes. My lord, that's my lord, it is written in the representation,
120.
page 120, that is on instruction, my lord, it is
And it is
written, but
still
till vacant or not, because of that in Ussosiri portal now in operation. So whether it is still vacant or not, it is
not known to
not
you.
known to. And another thing is that, my lord, kindly turn page number 84. My lord, kindly turn page number 84. There is a specific government notification. The consideration of transfer application and recommendation, page number 84, top portion, my lord. Consideration of transfer application and recommendation. Authority, Central School Service Commission. Timeline within 3 weeks. And in the second last paragraph, there is specifically mentioned my transfer application not considered for 27 weeks, 201 days.
All right,
Very
that
surprising.
the authority will
Very
respond.
surprising.
The authority will respond.
Grateful.
Service is taken on record.
My lord, I'm for the petitioner, my lord. My lord, my application has been forwarded by the school authority to the DI upon granting NOC. Oh, I'm so sorry. I'm so sorry. I'm in the 12. I'm so sorry. Wait. I'm in item number 12.
11.
11? Yeah.
Yes.
My lord, petitioner is seeking petitioner is an assistant teacher of Dubra Girls High School, Purulia. Petitioner is seeking transfer of said ground, my lord, on medical ground. Petitioner is not able to work and sit.
Self medical ground.
Self medical ground. Yes, madam. Petitioner made a representation for issuance of NOC. No objection. We have the school authority.
Presentation. Where is the application?
So this is no manual application, my lord. Petitioner made page 14 November. I have asked them the online mode. They have submitted offline mode, my lord. 14 November, page 49. Starts from.
It's only a represent. Please come. The petitioner seeks transfer. Stop. It appears that
And
the petitioner is yet seeks transfer on self medical ground.
Lower limbs of the petition has been operated.
Stop. It
Of
appears that
neuroscience.
the petitioner is yet to apply in the prescribed format seeking transfer. Stop. Next. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to apply online in the Utshosri portal seeking transfer, disclosing ground for the same. Stop. In the event such an application is made, the same shall be considered by the authorities strictly in accordance with law at the earliest. The fate of the application shall be made disposed.
And she is under treatment of Institute of Neuroscience, my lord.
12.
I'm for the petitioner, my lord.
Yes. Your other side?
Yes, I've served everyone. With me, all are appearing. The school has forwarded to the DI, page 81. Upon granting NOC, the general ground transfer, school has already forwarded pending before the DI for consideration. It's on general ground transfer, page 81. And NOC at page 78.
DI will consider application for transfer.
General ground transfer.
Yes,
Grateful, ma'am.
disposed.
Great.
This is the application for transfer of the petitioner on his own medical ground. That was previously rejected. He came before this honorable court. This honorable court directed to set aside the rejection. Thereafter, directed him to file an offline application again. So when that was filed, my lord, on the ground of his own medical problem, my lord, at page number 28, if your lordship sees,
Page number
28,
28. Yes,
the school rejects it at the ground of, my lord,
single teacher.
adverse PTA. He is a single teacher, yes. School will be suffering, my lord, the problems for which that has been rejected.
Self-medical ground, single teacher. You have any prototype order?
I can just hand up to your lordship's office.
Please give.
But here, my lord, the only difference would be, my lord, it has to be set aside. Page number 28 has to be set aside. The other,
Yes.
my lord, would be set.
Page 28 to be set aside. At order copy diye jabe.
I mean,
Huh? Self-medical ground, single teacher. Yes, disposed.
the affidavit.
Yes, service taken on record.
Yes, yes.
An order passed by this bench.
Yes, yes.
There are several.
Yes. Wait, please issue. My lord, this, my lord, I have got a similar kind of order. So this, my lord, is an application for single teacher. Previously, my lord, set aside, the rejection was previously set aside by this honorable court. And the contempt application which is preferred, my lord, which was preferred, that was said that the look into, my lord, the this alternative arrangement to be done very, my lord, page 22 has to be done. So after that, my lord, nothing has happened. So thereafter, my lord, I have come before this honorable. This
Then what
process-
happened to the contempt?
Contempt was
Since
in
schools
the-
have request to indicate willingness,
Yes.
no willingness.
Yes. So when I kindly sees this order once, this is absolutely same situation. Only one year has to be changed. That which I have done. In a similar situation where a contempt was preferred, similar order in the contempt was passed. Everything. Even, my lord, the district inspector is also.
And the judge who passed the earlier order was also same. All right. Same order.
My lord, the affidavit.
Yes.
The next matter is also same.
No, এটা contempt ছিল, তাই?
Same as 14.
Yes.
15 is same as 14.
Everything same.
Contempt
Yes.
year,
Yes.
year.
Here is different only.
There is also contempt application, page
Oh, I'm so sorry, my lord. Here is also same.
Here is also same. Check up. Then you'll come up with two
No,
pension.
it is also same.
22.
I'll change that.
22.
দিয়ে দিন।
With the affidavit. My lord, I requested my learned senior friend Mr. Bhattacharya, my lord, in the over the phone.
Which Mr. Bhattacharya?
Nilanjan Bhattacharya.
But I'm led by Mr. Bhattacharya. My lord, I had
There
a talk
he is,
with
yes.
Mr. Bhattacharya. Kindly fix them at around 21st, my lord.
Why it is a SLST matter?
Yes, second SLST matter.
My point is different than the matters which are posted on 21st. Be that as it may, if they want.
আচ্ছা upgraded motion Friday তে রেখে
Great.
দিন। Upgraded motion Friday.
Great.
The bundle remains the same. একই bundle.
আমার 7.
Sorry, madam. 15 I was appearing for the state. I just missed the matter.
You have missed, you've missed. What can be
I am for the petition. I am for the petition. Conversion from CPF to GPF.
17?
I am for the petition. Conversion from CPF to GPF.
দেখি কি দিচ্ছে।
Lordship, Mrs. Chandra Yalam is appearing on behalf of the respondent.
Wait, she,
She is engaged in code number 4.
call her.
Yes, Lordship.
Please call her. The dates are all right?
My lord?
The dates are all right?
Yes, my lord.
All right. Prototype is here.
Get.
That 18 minute I am for the petitioner, but that petitioner working in a school where the student strength is 0. Now, my lord, what happened in the year 2026? There is a recommendation from the West Bengal School Service Commission under 10C to reallocate the petitioner to another school. My lord, kindly turn page 16. That petitioner has been transferred to recommended for transfer Oroshankar.
Yes, some school.
Yes.
Then
Then, my lord, page kindly turn next page. That particular school has no vacancy. The school has intimated there is no vacancy. So that recommendation has gone. In the meantime, my lord, I have also applied for own seeking transfer before the district inspector of school, which is pending.
where is in the
That is
prescribed
page
format?
number 18, yes, madam.
But then
Page number 18 and onward.
to the DI, how can you do it? You cannot do it.
My lord, your lordships has passed at least 2 or 3 decisions to state
Yes.
since there is the school is non-functional school. There
No,
is
no, that is separate. Here,
sir, give me liberty to file a fresh application.
right now, Uchosri is there. You can file it.
So, if the my lord, kindly proviso be open if the my lord, non
All right, that is all right.
offline mode be open. If
The
not,
petitioner
and kindly observe
is
the
serving in a
school is-
school. The petitioner is serving in a school with 0 enrollment. Stop. An order of transfer under section 10C of the WBSSC Act was order of transfer is জায়গায় recommendation for transfer
recommendation.
under such and such was issued by the West Bengal Central School Service Commission in February 2026. Stop. When the petitioner went to the recommended school for joining, he or she, he was intimated that there was no vacancy. Stop. The petitioner thereafter applied for transfer to the District Inspector of Schools, Secondary Education, Tomluk. Stop. This Tomluk in March 2026. Stop. The same is alleged to be kept pending. Stop. Paragraph. It has been brought to the notice of the court that the Uchosri portal has been made functional presently. Stop. Next. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to apply in the prescribed format in the Uchosri portal. Stop. If it is not functional, tahale offline application করবে. And it will be considered in accordance with law at the earliest. All right.
Extremely great. Extremely.
Let 19, I appear for the petitioner. Let this is a matter of to increment the ground of PhD. The school has forwarded the application to the office of the district inspector, which is pending. If a lordship kindly turns to page 25, the school has already granted me leave for this study.
What is page 30?
What is page 30?
This is the
Notification, which I have,
notification
yes,
relying on which you want the
granting 2 increments.
benefit.
Yes. And the judgment passed by your lordship
on
Yes.
17th of August 2026. in the
Page
case of-
26 is the forwarding letter.
Yes, page 25 also. Page 25 has been forwarded by the school. Headmaster,
The school?
yes, I wrote to the school. The school has forwarded left portion here.
Yes.
The school has forwarded to the DI, who has accepted it. And my lord, kindly see the forwarding of the headmaster to the DI. Achha.
Page
And-
25, isn't it?
Yes. 26 also, my lord, where I personally in 2016, my lord, I personally wrote a letter, my lord, to the DI.
Very well, I got it. So it's pending before the DI.
Yes.
And the order, this you have shown where it was disallowed. Why bring this now?
The DI has disallowed on the ground of the embargo of 2005 notification, Control of Expenditure Act.
But then in your case, there is no
If your
decision.
lordship kindly mention, my lords.
Why skip steps?
Very well. Then, my lord, kindly grant me that leave so that I can produce it before the DI at the time of hearing.
What is your submission? You are for the state.
Send before the DI to consider it.
So it is already before the DI. Who am I to send it?
Kindly
The court
grant me time to consider.
to a post office.
No, Lordship. I'm just grant time, some time to consider the
The
matter.
petitioner's prayer seeking grant of 2 additional increments for acquiring PhD degree is pending has been forwarded by the school to the District Inspector of Schools, Secondary Education, Paschim Medinipur. In November 2025, stop. The same is alleged to be kept pending. Stop paragraph. According to the petitioner, he would be entitled to the increments in terms of the directive of the secondary branch of the School Education Department, secondary branch. In memo number, page 30, please take down, 37. Dated 5th January 2012. Stop paragraph. As it appears that the prayer of the petitioner seeking 2 additional increments is pending consideration before the DI. Accordingly, no useful purpose will be served by keeping the writ petition pending.
DI Paschim Medinipur.
The instant writ petition stands disposed of by directing the DI SE Paschim Medinipur, respondent number 3, to consider the prayer of the petitioner strictly in accordance with the directive of the School Education Branch, School Education Department, secondary branch.
Right, hearing.
At the earliest, but positively within a period of 12 weeks from the date of communication of this order, stop. If the prayer of the petitioner is allowed, the necessary consequential steps shall be taken by the aforesaid respondent without any further delay.
Let any chance of
Disposed.
hearing.
No requirement.
Very well. Very well. Great.
That I am for the petitioner, my lord, it is a distance ground transfer application offline mode. It is pending before the my lord school authority. My lord, a transfer application in prescribed pro forma, page 15 and onwards, my lord, school has not dealt with my transfer application. Is pending. So my lord.
Actually, the petitioner seeks transfer. Top allegation is that the application made in the prescribed format before the school authority is pending consideration. Stop paragraph. Presently, it has been made known to the court that the Uchshasri portal dealing with transfer applications has been made operational. Stop next. Operational and functional. Stop. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to apply in the online portal.
In online not permitted that clause be.
If online is not functional, then fresh offline application to be made, but it is made functional now.
Sometimes it is functional, sometimes.
At times when it is functional, please drop in. Wait for the opportune moment.
Madam, 21, my lord, I have got the petitioner, is a group C plot before your lordship, my lord, it's a medical ground transfer application.
Self-
Transfer application.
Self-medical ground?
Medical ground, the school already issued NOC and forwarded to the DI.
Where, show me.
Yes, my lord, kindly page 27, my lord. That's forwarded, page 24, school granted NOC.
Please come. The petitioner's application seeking transfer on self-medical ground has been forwarded by the school to the District Inspector of Schools, Behrampur, Murshidabad. Stop. The same is pending consideration for a considerable period of time. DI Murshidabad to consider. Disposed. আপনি এখানে দাঁড়ান. Yes, 22.
I am with the petitioner. Pertains to the high scale of pay, my lord. Kindly see the improved order, page 50.
There is a rejection.
Rejection, but it was rejected on the ground that the board was not sanctioned the study leave. Kindly see the relevant part, my lord, page 55. I am covered by the Utpal Kanti Karan before entering.
No, but Utpal Kanti Karan, they were required to consider.
No, my lord,
Even then, they have rejected.
No, my lord, kindly see that page 55, my lord. Last.
But this has to be heard. It cannot be done in this manner. Page
No,
55.
no, can you see, my lord, the said extraordinary leave, the study leave is not sanctioned by the West Bengal board for secondary education till date, so no relief can be granted. But the board, my lords, required to issue the study leave, my lord.
Yes. So if it has to be done, it has to be done.
My lord, can you direct the
One thing
board?
can be done, my lord. The DI has observed that since that leave has not been granted by the board, he is unable.
Then the
Although
board is required.
the board,
Secretary Managing Committee is the competent authority, lordship, to sanction leave without pay not exceeding 2 years as per the rule 7 of the.
Yes, it's all right. So the managing committee has not taken a decision.
No, lordship.
Second decision.
Where is the decision?
My lord. Page,
Lordship.
And is the decision
page
communicated
50, my lord.
to
Page
the
54, my lord.
page 54?
44, man. Double 44 and 45, man.
Submission of document of extraordinary leave.
Page 45, man. The improvement is also written, man, that the school authority communicated the decision to the.
And where is the document to show that the board has communicated to the DI? How will the DI get to know? The DI doesn't know it. Then
Therefore, can you direct the board, man, to take a decision, man?
board has to sanction leave and send to the school authority, and the school authority to communicate the petitioner, and petitioner at the time of hearing shall submit.
The board already issued a notice 8 April 2026 to the teacher in charge, Narendra High School, lordship. With reference to the matter as noted above, I am directed to inform you to submit copy of prior permission of the concerned DI for appearing at the MSc Part 2 examination, and Secretary Managing Committee is the competent authority, lordship. Board already issued a notice, lordship, on 8 April 2026, lordship.
page 44 considered by your authority? Page 44, there is already submission of documents before the board. The petitioner's prayer seeking higher scale of pay stood rejected by the DI SC South 24 Parganas on the ground that the extraordinary leave and study leave was not sanctioned by the board. Stop paragraph. Learned advocate for the petitioner has annexed a document at page 44 of the writ petition in support of the submission that the school authority has already granted permission for obtaining extraordinary leave without pay to the petitioner for completing his higher study. Necessary documents of the petitioner were submitted by the school to the board. Stop paragraph. learned advocate representing the board is directed to take instruction as to whether page 44 of the writ petition was taken into consideration at the time of issuing notice to the petitioner. Give me that notice.
Page 44 and 45, ma'am.
At 44 and 45, দুটো লিখবেন। At the time of issuance of the notice, being memo number, check the memo number. Dated 8th April 2026 to the teacher in charge of the subject school, seeking for the documents. Of the petitioner. Stop. Release the matter for further consideration on 16th of September 2026. A written report by the board shall be placed before this court on the adjourned date.
One thing, my lord, in the said report, my lord, they wanted the prior permission for applying.
Yes.
But before I enter into service, my lord, I completed part one.
September.
Be it recorded that the petitioner completed his part 1 MSc examination prior to joining service.
That has been recorded in the DI's order. September 23, my lord, I am for the petitioner. That-
23, my lord, 23, my lord, for the college authority, my lord, Mr. Shoibal Acharya is appearing, my lord. He is engaged in court number 652. He is on leg, my lord. Lord, my lord, I am just praying for not pray on behalf of him as he has been instructed me to just to pray for not.
What is your prayer?
My lord, no liability certificate.
By the college?
College.
Then college's presence is required.
My lord, then my lord, day after tomorrow, my lord.
All right, Friday. Listed niche.
বলেছে just have
24.
Item number 24, Mr. Bari has just left because his personal difficulties. Not
Yes.
only not.
Not today. 25. Your other side.
Initially, it was served upon the state. Thereafter, change of panel I have served on yesterday. A
Again.
fresh copy upon the learned office of the learned commentator. Now, difficulty is there is a 48-hour gap is required, which will be fulfilled on tomorrow.
Friday, I'll take it up.
Lordship.
Friday.
25.
25 below I am appearing.
He is appearing.
You are there?
Yes, my lord. I thought it
25?
is 24. I'm so sorry, my lord.
24.
This is 25.
25.
State the answering respondent?
State is the
Yes,
answering
ma'am.
respondent.
All right. Take it, 25
But here, only difficulty that I am facing with the petition, my lord, which has been uploaded, my lord, several illegible documents. I shall indicate the pages.
What is his prayer?
My lord,
But for regularization of service.
my lord.
The petitioners are the petitioner is the teacher of a EMRS school, which is established by the central government for provide education to the scheduled tribe students. It is a special school established by the central government. Now, petitioner is working as a contractual staff in that said school. He is praying for regularization on this ground that other schools of different states of Tripura and Odisha, they have been regularized pursuant to the order passed by the Honorable High Court of Odisha as well as Honorable High Court of Tripura.
Show me the law which permits
Lordship.
regularization.
Lordship, I am coming to that.
That is also illegible, my lord. P6,
Then please give legible copies.
page number.
I'll take it up.
49. Can you
When-
have a look,
when?
my lord? I don't know whether my lord said legible.
Doesn't matter. He'll provide
49
legible
perhaps
copies.
is legible. It is during
Maybe
the uploaded, it becomes, so I'll serve a fresh copy upon him.
When?
Any day.
Friday, my lord.
Friday? Friday.
I shall come back.
26.
একটা কপি দিয়ে দিচ্ছি আপনার অ্যাড্রেসটা দিন আমি কপি দিয়ে
And the secondary board.
But I am from the DPSC Purunendipur.
Yes.
My lord, this case, my lord, relates to rejection of compassion appointment, my lord. The rejection was by the
Who was-
Commissioner of
Your
Commissioner
mother
of
was
School
the
Education.
death of the petitioner's mother in harness in 2008.
Yes,
Application made in 2008.
yes.
Petition disposed of, directing petitioner's claim. Second writ petition 15. First rejection in 17. Rejection caused. Claim rejection by the commissioner. Again rejected.
After this rejection, my lord, I had
Again
once again
rejected.
approached
What is the ground for rejection? Repeated rejections?
And a repeated rejection, my lord, they are taking the ground of financial hardship, my lord.
All right.
First time on the last occasion, they have simply stated, my lord, kindly sees paragraph 10, kindly sees the perversity of the order. Paragraph 10, my lord.
Page
Page 63.
63.
Yes.
Yes.
After considering the very fact of the instant matter, petition has survived for more than 10 years after the death, my lord. And they have rejected on these grounds.
Yeah, this was in 2018.
Yes.
Then?
Thereafter, I have reapproached them by way of a representation. It was again rejected. Page 64, my lord, kindly sees. Page 64
Cannot be considered.
cannot be considered. Page 65, this is another representation. Kindly sees page 66, my lord. Page 66, the Deputy Secretary Government of West Bengal writes to the DI
And
primary.
you filed the writ petition in 2026.
Yes.
So the initial rejection which got set aside by the court?
No, my lord, there was a writ petition whereby, my lord, kindly sees the order dated 23rd February 2015, my lord, page 52.
Yes.
And I shall read the operative portion, my lord, page 53. Considered the submissions made by the learned counsel, it appears that the matter is pending since April 2014. Commission of School Education, who has sent all the papers, ought to have taken a decision by this time. Accordingly, Commissioner of School Education is directed to take a decision within 3 weeks. Thereafter, my lord, contempt application was preferred because no action was taken pursuant to the direction of the writ court. And kindly comes to page 55. 55, in the contempt proceeding, it was informed that a purported order dated 31st January 2017 was already passed.
Now you assail that in the next writ petition, page 56. For
Page
appointment.
56.
Where is the 31st January 2017's communication?
And that is not here, my lord.
Why have you not done it? Anyway, what does the order say? On the ground.
And here, my kindly sees considering, my lord, second paragraph.
Point of time is 5,000. The petitioner's monthly income more than the ground. Then
On that ground, because it was not clear as to whether how this ascertainment was made, it was set aside. Direct the school commissioner, my lord, page 58, my lord. Direct the commissioner of school education.
But right now, tell me, from 2008 to we are in 2026. Can there be any direction for consideration of your case on compassionate ground?
Here, my lord, the question is whether my lord is willing to entertain this writ petition and this is a matter of discretion, my lord. Here is a case where the petitioner was repeatedly rejected, my lord. Also, kindly considers that the rejection is based on perverse grounds. They have not properly considered my application at all. I am in need of a job. I have been trying since 2013. A mandate has been set by the Supreme Court that compassionate appointment applications must be disposed of within 6 months. Well, to enforce that mandate, I have had to approach the court more than once. Now, this is a clear example of a might is right, my lord. They are hell-bent on depriving me of that appointment.
But
I
you
have
to show that you fulfill the criteria, the
yes,
income criteria.
Yes, I fulfill, my lord. Kindly comes to the impugned order. My lord, this is in violation of the division bench decision in Bitoshok Mahato. My lord has also passed judgments in Onamo Jana, whereby, my lord, the dearness allowance, medical allowance, etc. have been taken into consideration while deciding family income.
Where is that?
Paragraph 9, my lord, kindly comes, page 62. Kindly comes to paragraph 9.
As per PPO, basic family pension was such and such.
Ma'am, Bondita Pahari was the mother of the petitioner.
Yes.
Thereafter, she died in harness, my lord. Family pension was sanctioned in favor of the petitioner's father. Thereafter, it was detected petitioner's father had a second wife. Therefore, PPO was withdrawn and family pension was stopped in favor of the petitioner's father. But the petitioner was all along a major, my lord. He was not entitled to family pension. So all these grounds, my lord, being taken into consideration by the Commissioner of School Education in saying that family income is greater than the Group D employee's salary. Also, they have not said.
Who's for the state? Who's for the state?
The state is absent today also. Last occasion, my lord, made it not today.
Engaged.
But I have to find that out, my lord.
You should have found out in the meantime, because it is their rejection. Yes. And they are the important parties.
I have
out who's there.
I have served them, my lord, multiple times. Kindly cease the affidavit.
Please intimate the learned counsel who is appearing for the state that the matter is appearing.
My lord is taking it up on Friday, my lord.
If you want, I can keep it on Friday.
My lord, if my lord can pass it over, my lord, I shall
I can
ask.
pass it over also.
Kindly passes it over.
All right, pass over. Please call the fixed matter. Who is the other side? Who is your other side? Did you get hold?
The other side appeared and said, yeah. And the
Yes,
senior
where is
was
the
asked.
senior? Where is the senior? Rahul. Give the other matter. Please call the senior counsel.
My lord, I called the senior, she didn't pick up the phone. I have
Yeah,
the phone.
maybe in court, right now it will be recessed. Please call, it is passed over. देखिए State. Where is your senior? Microphone, please.
Firstly, Milord, I'd like to apologize for my words. I'll be careful from now.
Where is your senior?
She's really unwell, Milord.
Yes?
She's really unwell. She hasn't come to the court today.
You just now said that she is
I tried
engaged.
to I tried to contact her, but she's really unwell. She hasn't come
Not
to.
make any untrue, unverified submission in court. You are a very junior member. You'll not be able to come out if you get trapped. Never do this. Tell your senior to come. Will she come tomorrow? You do not know.
She's unwell, but I'll.
She is unwell. In that case, I'll make it not this week. In the meantime, you serve the school. The school.
School, Milord, post mentioning by email. I have served notice. I have an affidavit of
Alright, if
service.
you have an email, then you can always serve. Hearing of the writ petition stands adjourned as due to unavailability of the learned advocate representing the state respondents. Stop. Release the matter on next Wednesday, 26th, and let further notice be served upon the other non-appearing respondent. Item 26, you want on Friday? Friday. All right, Friday. 26, Friday. Listed niche Friday.
There are two matters. First is the morning matter,
Hmm.
item number 3, which your lordship has been pleased to fix at 2. And the other is item number 81, which is originally fixed on 2, which your lordship is saying.
Which one would you like?
3. Because my lord,
এই pass over যেটা হয়েছে।
তুমি ওটাকে দেখি
the affidavit of service,
আমার কপি নেই এগুলো
সব আছে, সব আছে।
where it will appear that he had
আরেকটা লজকে তো দেখবো
See, I only want the presence. I do not want to see
Right.
whether you have served, not served. As long as somebody is present, I am okay.
Today, after the item number 3 was taken up, another notification has been issued. Just marking this today.
The
yesterday not today no yesterday
yesterday আজকে 19
আজকেই উঠেছে কালকে ডেট দিয়ে আজকে উঠেছে আপলোডেড ঠিক আছে
for the purpose of such EWS certificate must have been issued before the date of the interview.
again
That means it remains open
crucial date.
till the date of the interview.
Now my lord, may I just place the report which was placing? I think my lord, the report has been filed in the court.
Does the next line have any importance? EWS certificate issued on or after the date of the interview shall not be treated as valid after interview. If then
Nothing. Yes.
you will consider the certificate. Is it possible?
Just a minute. May I just find out the state's second exception? This is the reply. First report.
States second
না নেই তো
report.
কোথায় সেকেন্ড রিপোর্টটা
দিয়েছে আগের দিন কত জমা করেছে?
দিয়ে দিয়েছেন
হ্যাঁ,
What is the date? Is it 13th of July?
ফ্রাইডে ছিল যেদিন।
report affirmed on thirteenth of July. It's there. Now, my lord, kindly cease. Your lordship was pleased to direct them to disclose the circulars. Now, first circular I have drawn your lordship's kind attention is now kindly comes to page 4, their averments. Page 4 of the report.
Yes.
It is pertinent to mention herein that the written examination was held on 30th 11/2025.
Hmm.
Result of the written examination was published on 29/12/2025. It was revised on such and such. So 30th 11/2025 is the written examination. Now kindly comes to the next paragraph. That there any candidate who applied under the EWS category has got reservation benefits under the EWS category on and from 30th 11/2025. So in the report, they have taken a stand that we have given the EWS relaxation till 30th 11/2025, which is the date of written examination. Today's circular that I have handed over, they are saying date of interview. Now kindly comes to, though this should be the crucial date would be, my lord, 5th April 2024. That is the charge.
Last date of filing the application.
Yes, application. That is the crucial date. 5th April 2024, upheld in, my lord, Yadav, upheld in, my lord, interpreted by the DOPT, everything. আচ্ছা আমাদের এক্সেপশনটাতে প্রথমটা সেকেন্ডটা তো লাগিয়েছে এক্সেপশন টু ফার্স্ট এইটা একটু বার করে দেবে আর আজকেরটাও বার করে দেবে এই যে এক্সেপশন নাও মে আই জাস্ট টেক ইউর লর্ডশিপ
ওরা যেটা পাঠিয়েছে স্প্যামে চলে
আজকেও একটা দিয়েছি সেটাও দিতে পারেন না মাই লর্ড R1 page 7 they have taken a stand.
This report only?
Yes.
Page 7. Yes.
Before that, may I just bring your lordship's attention to page 3, and thereafter I'll go to R1. They have proceeded on a totally misconceived notion. That is to show. Page 3 is copy of the rules of such and such. R1, same principle in respect of reservation of EWS category as followed by the West Bengal Police Recruitment Board, and it is relating to the reservation of EWS category. Now kindly sees R1 they have followed. Kindly comes to R1. This on the last occasion your lordship was pleased to disregard. This kindly comes to page 7.
Yes.
R1 was shown in the first report also. In the second report also they are saying this is 2012. At that relevant point of time, EWS not there. With reference to the memo on the subject mentioned above, the undersigned is direct to inform that the reserved candidate is entitled to get benefits of reservation from the date of issuance of the caste certificate. So this was with regard to SC, ST. Difference between vertical reservation and EW is that it doesn't vary from financial year to financial year. This Poonam Pandey. After the application is submitted and during the recruitment process, if any caste certificate issued by the proper authority, the appointing authority should also consider the same caste certificate of the. So this was with regard to caste certificate, not with regards to EW, is not applicable, but they are proceeded on this basis. Now thereafter, kindly comes to page 9. Page 9 is the communication made to them by the backward classes pursuant to your lordship's order in this matter. With reference to the above, I am directed to provide the existing such and such. This matter has been quoted. WPA number such and such can Sudipta Chakraborty. Now kindly see, this is the office memorandum which we had relied upon, and the relevant part would be clause 5.3 that I have shown in the morning. এটার পরে গৌরব সিং ডাইরেক্ট চলে যাবে, এটার পরে আমাদের এফএকিউ, তারপরে the crucial date for submitting income and assess certificates by the candidate may be treated as the closing date of receipt of the application for the post, except in cases where crucial date is fixed otherwise. Here there was no fixation. Now kindly comes to the FAQ. This was also relied upon by me. But however, they have only annexed one page of the FAQ. I will show your lordship the entire FAQ, which was relied upon and which they have not annexed. They have annexed internal page 6 of the FAQ. And this is the entire FAQ, which has been annexed in my previous exception. Now also to this exception, if your lordship wants to take the previous exception, I'll be requesting your lordship to take this exception by of an affidavit on behalf of the petitioner. This is dated 15 June 2026.
Have you mentioned it as exception or affidavit in reply?
Exception.
Exception.
By way of an affidavit on behalf of the petitioner above named to the report filed on behalf of the respondent. In fact, I have annexed this today also, but I want to show it from the previous exception so that if your lordship has marked it, it will be easier for your lordship. এটা opposition, এটা না, এটার পরেরটা যাবে। এটা দেখি তো কানে দেখি। Reply.
অর্ধেক কাগজ কি সামনে আছে? ওগুলো কি?
এটাতে নেই।
Affidavit in opposition on behalf of the petitioner. This is.
This your lordship has recorded in your lordship's previous order.
Wait. Exception 15 June আমি দেখছি দেখতে তো পাচ্ছি না না আমি দেখছি you annexed it today is in exception.
Today also I have annexed. I was drawing it from your previous because
Show it from here.
lordship might have marked it, so therefore আজকের exception টা থেকে দেখা. Exception to the second, yes.
Page 21 FAQ.
Yes.
Hmm.
The FAQ starts from page 21.
Hmm.
And thereafter, the clause that I have relied upon is at page 25, question number 21. This has been issued pursuant to orders of the Supreme Court. I have relied upon, I'll show again, one paragraph. Question number 21. Crucial date for income and asset certificates.
Hmm.
Paragraph 5.3 of DOPT order dated such and such, I have drawn your lordship's kind attention, the state government is annexed, provides the crucial date for submitting income and asset certificate by the candidate may be treated as the closing date of receipt of the application for the post, except in cases where crucial date is fixed otherwise. The crucial date for submission of the income and asset certificates cutoff date shall be clearly mentioned in the advertisement published by the recruiting agencies. Income and asset certificates issued subsequent to the crucial date and for the later financial year shall be treated as major discrepancy. So first is it has to be mentioned in the advertisement itself. Subsequently mentioning will not do. In this regard, the order dated such and such passed by the Honorable Supreme Court and UPSC Gaurav Singh is may be referred. UPSC Gaurav Singh I have referred. Just once, I'll just read out the UPSC Gaurav Singh paragraph. 2024 2 SCC 605, paragraph 7. It has been, well, on the last occasion, your lordship has been pleased to take note of this. In terms of the notification,
I can find out Divya over here.
Divya is there, UPSC Gaurav Singh is there.
Yes, your 15th June's exception is here.
Yes, yes. Lordship has been pleased to find.
Gaurav Singh is here.
Yes. Kindly comes to paragraph 7.
Yes.
Internal page 609
Yes.
of the report. In terms of the notification dated 31st 1 2019 referred to above, the benefit of reservation under the EWS category would be available upon submission of an income and asset certificate issued by the competent authority for the financial year prior to the year of application and the closing date for receipt of the application for the post as to be treated as crucial date for submission of income, except in cases where different crucial dates are fixed. So two criteria. Prior to the year of application, that also they have violated, I'll just show. And the closing date of receipt of the application. And except in cases where different crucial date fixed, if it is fixed in the advertisement itself, subsequently it cannot be fixed. Now, my lord, kindly comes to the writ petition once, or my lord, now the exception given by me today. What they have done. Page 28 that I have drawn your lordship's kind attention in the morning. Now the later notification, they have fixed the date of interview as the date. Now kindly comes to the options that they have given. In this 12th August 2026 was the date when the division bench was hearing the OBC matter. The subsequent OBC matter where all OBC certificates issued during the interregnum has been cancelled by the Honorable Division Bench arising of this court's order of UGC GenPack matter. Now, my lord, on that day itself, they have issued this. Of course, now they cannot proceed with this. This is the first page 28 that I have drawn your lordship's attention to. Now kindly comes to the screenshots of the options which is required to give in. Kindly comes to page 33. First is they cannot, my lord, convert the OBCs now into EWS. That will be the change of the rule after the game has been initiated. Second is that also they have done erroneously in view of the judgment which they were, of course, they didn't knew at the time when these options were given. I will not blame them to this extent. They were not supposed to. In terms of the page 33, in terms of the order, government order dated such and such, 18th May, of backward classes, department of such and such, candidates belonging to one such and such who have been included under the state list of 66 classes of OBC to avail 7% reservation, but were not in the earlier state list of 140 classes of OBC AB, while their earlier notification dated such and such, are requested to upload their OBC certificate issued on issued or re-evaluated on or after 1/1/23 to get the benefit of reservation under OBC. This I'll show is contrary to the order passed by the division bench, because the division bench has been pleased to hold. I will just read out and thereafter give. Paragraph 25. Is the observation, and previously previously it has in paragraph 21 onwards, it has been held by the division bench. At the risk of repetition, it is stated that the state has specific legislation in the form of the West Bengal backward class other than scheduled class, scheduled tribes. Paragraph
25.
21 is the reasoning.
But is it not the same bench? It's a different bench.
No, the honorable senior judge is there.
Yes. Shreyoshi Dang, is it from the order passed by this bench?
Shreyoshi?
Which is certain.
Shreyoshi Dang, this bench.
Yes.
At the risk of repetition, it is stated that the state had specific legislation in the form of the West Bengal backward class other than scheduled class, scheduled tribe, reservation of vacancies. It could not have been resorted to Article 16(4) of the Constitution of India, and that too under the West Bengal Commission for Backward Classes Act 1993. The said Act of 1993 did not empower the state to declare classes as OBCs for the benefit of the service under the state. In the light of the above, while it is true that the appellant writ petition herein and obtained an OBC A certificate on 13 April 2026, such certificate was obtained under the notification dated May and June 25 that are void ab initio. The certificate of the petitioner dated such and such is therefore invalid for having been obtained under the void executive order. In the light of the above decision, the writ petitioner could not have been part of any OBC category and hence could not have an OBC certificate as per certificate per se, unless it was applied under the pre-2010 existing classes of OBC. The formal withdrawal of the void notifications issued by the state from 8th May 2025 till 12th June 2025 by Gazette notification dated 18th May 2026 is therefore based on the court's judgment dated 22nd May 2024. This is the main judgment. The said notification do not exist by reasons of their withdrawal, and such non-existence would date back to the day when the notifications were issued. Alternatively, the said notifications were void ab initio in view of the observation of this court already made hereinupon. It is therefore found that all OBC certificates issued by the state between 8th May 2025 and 12th June 2025, and those certificates that were issued in interregnum between 10th June 2025 and 18th May 2026 would also be all no consequences and void ab initio. Persons falling within the OBC category under the classes existing prior to 2010 would have to apply afresh for certificate of OBC. If they fall within the classes that have been saved by the judgment of coordinate bench dated such and such, so fresh application. Here they have sought for the OBC certificates which were already there, and subsequently, that is 2023 certificates they have sought for. In the light of the above, none of the prayers made in the writ petition could not have been entertained. The writ petition was rightly rejected by the single bench. The petitioner and the other persons who participate in the national eligibility cum entrance test claiming to be OBC under the central list or under GenPAC UG conducted by the West Bengal Joint Entrance Board must be treated as general category candidates. So here, by this notification, they are converting the OBCs into EWS. First is OBC primarily cannot be an EWS because of the differences. And second is here. The state or the appropriate competent authority concerned may in their discretion take appropriate measures. This is the policy decision. This I pleaded before the Honorable Division Bench. If the Division Bench is cancelling all the OBC certificates in respect of national level examination, then the OBC candidates of our state will be facing difficulties. So therefore, state, if once they can come up with the policy decision that yes, we are keeping the OBCs alive in respect of others, there has to be a policy decision, and then only this can be this judgment. The Honorable Division Bench was pleased to observe that if the state comes with a policy decision, then this order may be altered. That was the oral observation of the Honorable Division Bench. But as of today, it is they are general category candidates. Next, page 33 again. Candidates who appear at the interview as OBC category A and B, despite possessing an EWS certificate and have been excluded from the list of such and such, may also upload their EWS certificate valid for the year 2023-2024, subsequent financial year, or onwards till 2024, 2025, 2026, 2026, 2027 also, to get the benefit of reservation under the EWS category. Else they will be considered as UR category candidates if fulfills the conditions there. Your Lordship has rejected in this net matter change of category. Kindly seize your Lordship's order. Dutoi de. Your Lordships, the longish order is in Hasibur Rahman. Hasibur Rahman ta de. Eta দাদার জন্য নিয়েছিস হাসিবুর রহমানটা? Paragraph 29, 30, 31 এটা দাদাকে দেয়া। ইন্টারনেট থেকে WPA 21501 of 2026. 21501 of 2026. Paragraph 29, 30, 31. Lordship has considered Divya, Poonam, everything. May I just read out for the benefit of the learned advocates appearing for the state. Page 8. The petitioners, at the time of filing the application application form for appearing in the net, did not disclose their category as EWS. Specific disclosure made in the application form as regards category is either general or OBC NCL. The same implies that at the time of filing of the application form, the very first step for admission in the medical course, the petitioners were aware that they do not belong to reserve category and would not be entitled to get the benefit of reservation. One of the candidates in CAN 2 is this category. She did not disclose that she was an EWS while filling up the form, subsequently obtained the EWS certificate. The first step in the admission process was in the unreserved category. None of the candidates possess EWS certificate on the date of filing of the application form for appearing in NET. The petitioners allege discrimination on the ground that the notice of the state permits the candidate belonging to general or OBC category to state their category status afresh during the registration process of counseling. There is no provision for fresh disclosure of category status in such and such EWS category. The aforesaid submission of the petitioners appears to be absolutely fallacious. The petitioners ought to have appreciated that the candidates are required to disclose their category status at the time of filing their applications form for admission. For getting benefit of reservation under the EWS category, the candidate ought to have possessed a valid EWS certificate on the date of the filing of the application form. That is crucial date. Subsequent possession of EWS would not change the status of the candidate declared at the time of filing of the application. So this is, my lord, thereafter, paragraph 35, one line, that they are trying to do it now, that your lordship has held. A right has acquired in favor of those candidates who secured a position in the All India rank list. So therefore, now if they publish the appointment notification, right will be acquired. As of today, that is not right. No right. Page 38, paragraph 38. That is with regard to the petitioners, they cannot overtake and try a steal. And thereafter, paragraph 40 and 41 is Divya and Poonam with regard to cutoff date. Now, another writ petition was moved before a lordship on the same date.
It stood also dismissed on relying on this.
There, the prayer was change of category. That is what I am saying. Here, they have prayed that, look, give me an option of filing subsequent certificates. Here, it is change of category. It's totally what they have done. Jasmine.
What have you done on these papers?
Well, I don't know. Must have taken the tiffin. So,
This was actually a plate.
কি ছিল আজকে ওখান থেকে ফরেনসিক করলে বোঝা যাবে কি ছিল কি খেয়েছিস Jasmine Manor, Lordship has reiterated the previous 6 petitioners have filed. They participate in national eligibility test in the jail. Presently, the OBC status of some candidates have been cancelled due to several pronouncements of the honorable court. All petitioners pray to allow them to switch over from their respective category to EWS category.
Any appeal preferred?
I don't know. But in any case, your lordship has merely reiterated the settled law.
No, this is all.
Yes. So, my lord, now, my lord, coming down to the petition again, kindly takes up the writ petition. and your lordship judgment is there. Kamala Kanta have, it
Yes,
is there
it's
in the record. Now, my lord, here kindly comes to the notification at page 15.
Of the writ petition?
Yes.
Yes.
This is the notification. I can't do that.
5th of March 2024.
6. Yes, yes.
6th or 5th? It is
6th.
6th March. All right.
6th or 5th. What is happening nowadays is they are just uploading it. Now, before clicking, the date of the notification is appearing. After it is clicked, when the PDF comes, there is no date in the PDF. That is the difficulty in all matters that we are facing. B. In terms of the memorandum number 5959 BCW dated such and such, this is one of the memos which I have drawn your lordship's kind attention to.
Let him conclude today. I will have.
No, tomorrow is the date.
The matter will be concluded today only, after hearing both sides.
All right, may I take your lordship? Yes, 15 minutes.
Yes. In terms of the memo number such and such dated such and such, this is this memo which they have, my lord, brought on record and is at page 32. If your lordship is marking, then lordship may mark this. Because 32 of today's report. Lordship may not open. That is, may not open. Why I am saying this? Because I am in a habit of marking this.
No,
in
yes,
which page?
otherwise it becomes difficult. Today you filed an exception. They did not file. Did they file?
They filed. It is there. Prior to that date, it was there.
13th of July.
Yes.
13th of July, page?
Page 32.
Page 32. May 2023.
18/5/2023. 959.
Yes.
Of backward classes such and such. This 18/5/2025 clause 5 is relevant. Validity of EWS certificate. EWS certificate is valid for the financial year of the issuance of the certificate. Only for that. The candidates from economically weaker section, if shortlisted for interview, must produce income and asset certificate issued by the competent authority valid for the year 2023-2024 or onwards, issued for financial year 2023, 2022, 2023 or onwards. So financial year. Financial is the previous year. During checking of the category must provide EWS certificates and such. Now kindly comes to next page, clause I. They have shown this to substantiate that subsequently also it can be produced. I should, my lord, place its entirety. I. Shortlisted candidates for interview shall upload relevant certificate as follows wherever applicable before downloading the call letter for interview. So they are proceeding on the basis that interview date is the cutoff, which would also be reflected in today's notification where they have taken the date of interview. Though in the affidavit they have said that they are proceeding on the basis of written examination. Age proof such and such. B, C, D is income and asset certificate. Next page, last clause. This is their case, that which they have made out, but I should point out, otherwise it is very difficult. Candidates belonging to economically weaker section must produce income and asset certificates issued by the competent authority as per specific format valid for the year 2023-2024 or onwards, issued for the financial year 2022-2023 or onwards. So it is valid for the year 2023-24. What is valid? The financial year of the previous. That is
Till this much, it is all right.
Yes.
The moment you add
onwards, it
it
has to be
becomes-
construed. It has to be construed. Onwards means till the date of crucial date, which is subsequently. Now kindly comes to page 20.
Here also it is mentioned if the candidate is shortlisted for PMT and
Yes.
PTN thereafter under EWS fails to produce the valid certificate at the time of interview.
Time of interview.
But then it has to be the earlier
On that
certificate.
date. Now kindly comes to page 20. Hello? 54. বলবো। Period of application. Application window for submitting application through online mode only will remain operative from ato to ato. So last will be 5th April 2024. So that is the crucial date. Now, my lord, after the process has been initiated, though since they have pointed out, my lord, I should, my lord, interview is page 25. Interview candidate here, UR or EWS, that is okay, means they have stated in the previous also. Now kindly comes to the option that has been given. Page 50 is the admit card. Page 51.
You are a general category candidate.
Yes.
All right.
EWS category.
Oh, you are EWS.
Yes. Kindly see EWS community. It is there in the application also. Kindly comes to page 51, call letter. This is the date of interview. I was called in the interview, so therefore written everything done. Date of interview is 30th January 2026, Lordship has seen. Now, kindly comes to page 54. This is the editing window that they give. Such and such. Issue date of income and asset certificate within bracket must be on or after 1st April 2022. So open-ended. And 1st April 2022 would be the financial year of 2021-2022. Previous, hit by Gaurav Singh. Paragraph 7, prior year also. Now, clause 4. Same thing.
Clause 4 of?
Next page. That is the
Page.
documents uploaded and all these things.
Okay.
Same. After such and such. Why I tell, my lord? They were in a hurry before the election.
So anybody who just comes up will be allowed.
They were in a hurry before the election. That is why we have moved Chandandara. That is why the first Chandandara, second Chandandara. And since the matter was being moved, and at that relevant point of time, luckily the elections were declared. The learned government leader, Mr. Swapan Datta, at relevant point of time came and said that since the MCC has been declared, we will not. But they were trying to do it very fast. OBC A, B, everything, go inside. Thereafter election comes. That is the undue haste. Now, my lord, thereafter, page 56. 56 is the shortlisting. 57 is the date. Kindly see 57. That they are said this is the appropriate one. E. Income and asset certificates for candidates. Page 57, Lordship is there. Lordship might have marked it also.
Yes.
Economic vehicle section 23-24 or onwards. Next page was only 23-24. So they say they have taken the plea that this was erroneous. Now, here, my lord, I have shown the editing window which they have given, which is subsequently given on 12. That is also erroneous. And my lord, exceptions and everything. Oh, now kindly takes up Can 2. Supplementary affidavit of Can 2. Your lordship was pleased to direct. Kindly takes your lordship's direction dated 23/6/2026.
Yes.
Paragraph 23. I have placed the other paragraphs. I will not trouble your lordship again.
Right. 23 affidavits were directed.
Yes. Applicants are directed to file an affidavit clearly indicating the dates on which applications were made for obtaining the income certificate. Now, my lord, they have filed a supplementary affidavit. Supplementary affidavit are there. Now, প্রথমে ক্যানটা দে ক্যানে অ্যাপ্লিকেশনটা আছে দাঁড়া এটা হচ্ছে রিটের সেটটা এটা বাদ দিয়ে সাইড করি দাঁড়া এখানটায় রাখছে হারিয়ে না যায়
In Can 2, there are 2 applicants.
Yes, kindly seize their applications.
Yes.
Page 58. Can 2.
Yes, Can 2.
Category.
UR.
Category UR.
EW is not available.
Not applicable.
This
is one category that your lordship has said that
the
next is EWS. Yes, she has claimed. Now kindly seize her application. This is the filing date of application 28th March 2024. Next page, last is their application. Now kindly takes up the supplementary affidavit. Supplementary affidavit. Which is? Yes. অ্যাপ্লিকেশনটা এটাও তো দেখাতে হবে
Yes, supplementary affidavit.
First is application for EWS certificate is at page 7.
7.
And this is the date after the crucial date.
When was the last date?
5th April 2024.
This is 25th of July.
Yes. And he has claimed himself to be not to be EWS category.
Yes,
UBAR.
initial.
Yes. Next is, now lordship may kindly remembers the acknowledgement slip. The form. This is a form under the DOPT circular. This acknowledgement slip. And thereafter, for the subsequent year, another he has applied. That is, I think, এটা পেজটা কেটে গেছে, এটা হবে হচ্ছে, এটা যদি 10 হয়, then it's page number 9. This is, I think, for the subsequent financial year, 2025-2026, acknowledgement slip,
30th of June.
June 2025. This is for the EWS certificate is in the next page.
Hmm.
Now kindly sees application for EWS or for the applicant number 2. Page 11, who has claimed herself to be the EWS. When? On 20th March, when she had filed.
Where do I get that?
And kindly sees
Which page?
page 11.
Page 11 is a letter.
Yes, this is the application for EWS certificate, not even the acknowledgement slip.
This is 1st of April 24.
Yes. Open-ended, anytime. Even today they will be going. And that too by of a letter. Next is, now I'll show you, Your Lordship. Next is valid for such and such, 2024, 2025, they get it.
Hmm.
And this is 2025. Now it is acknowledgement slip. So, two categories. Crucial date and persons who have not applied as an EWS category. They also all being allowed. Now kindly takes up the first exception of the state government.
Prayer in Can 2.
Can 2 is addition of party and consequential
Yes,
directions.
but then what is the main relief that they are claiming?
Just a minute. Dismissal of the writ petition.
So they want themselves to be treated as
EWS category. Yes.
Yes. Then
Leave to add party and to direct writ petition to amend the cost title accordingly to hear the writ petition on merits pass such. Oh, they have obviously if, until they are added, they cannot pray for dismissal. But in my, I always pray that it should be done. Any case, now kindly takes up the first report of the state government. Actual matrix টা কতজন এখানে আছে, কতজন ওখানে আছে. First report, exception to the first report, exception. Second report. This is the report dated 5th May 2026. Now, my lord, they have said in the report, Your Lordship was pleased to direct specifically to say the numbers. Paragraph 18, the total number of 914 candidates submitted their EWS certificate valid for the year 2023-2024. We are this category. The seats which were reserved for EWS category were Kolkata. Yes. 1816.
vacancy in EWS is?
Yes. 816.
816.
816. Male, female, 816. Male, 576. Female, such and such. Submitted. And total of 1775, which has now been amended 1 or 2. You have said in the last report that it will be 1778, I think.
Addition has been there.
Addition. Mere 2, 3.
After the year 2023-24.
Yes.
During the interview.
Yes. So my prayer before Your Lordship would be these 914 candidates who were having EWS certificates prior to the crucial date.
They are
may
genuine
only
and
be
the
allowed.
valid ones, and
Yes.
the 1775 or 78 should be
Yes,
not
and
be
they
treated.
should be, their EWS certificates which were valid at that relevant point of time should be considered. They should be given an opportunity to show their main certificate.
Had they any other certificate, they should have.
Every year
everything
they have a
should have
certificate.
been, uploaded, isn't it? If it is-
Every year they have a certificate because
Right, so-
economically weaker section prior to the moment the financial year comes, they apply and
Yes.
thereafter they get the previous.
Right.
So only candidates who will be able to show their EWS certificates in respect of this year, that is financial year 2022, 2023, valid for financial year 2023-24 would be allowed. This is my submission. And crucial date is the main thing and the other subsequents should go. These are my submissions. May I start the next matter until they come?
No. All will get jumbled up.
Acha, acha. ठीक है. Dark DN.
Where is
Oh,
Mr.
acha.
Sanyal?
He is here. You continue for some.
Call him, call him.
Only one, two things.
Divya, may I?
Is hearing this matter finally.
Yes.
If so much, kindly give us liberty to take exception to the report of the state and the affidavit filed by state. Because I
You've
have
already filed your affidavit.
no matter. I'm not able to file my affidavit. I filed my application and two for admission of party.
Huh.
Your Lordship directed to file their opposition to my application and can't be liberty to file my reply. But we used our
So in the application stage, it is there.
yes. Let our applications be allowed and let us permitted to take exception to that their affidavit sent by others because we have not been given sub with the copies. We have not.
You have everything. It is there in the
No,
Shartak portal.
No, I have only the read petition, the copies of the report.
Yes. The read
Copies of
petition
the-
you have.
Yes, read petition I have. The copies of the report.
Report
Which
you do
was
not.
submitted by the state, take exception by one senior friend. That got to be looked into. That got to be.
There
replied.
is nothing in the report.
Yes, but there is because why I'm saying, my lord, they have challenged filed this at a stage when they got unsuccessful in the selection process without.
Okay, I'll show.
Without challenging the recruitment notice, because recruitment notice itself says what is the crucial date. But my learned friend shows on the DOP. You can also kindly see the DOP once for my satisfaction. DOP ticket. Exception আছে না?
On a second report.
Come to the DOP. Near page 3, page 12 of the exception used by my learned senior friend. The report filed by the state. Page 12. Near page
Yes.
it says 5.3. The crucial date for submitting income and asset certificate by the candidate may be treated as the closing date for receipt of application for the post. There is an exception, except in cases where crucial date is fixed otherwise. Now, not kindly come to the recruitment notification. Annex in the rate petition itself. But kindly come to page 15 and accept you. Got it?
1.5.
1.5. This is the recruitment notification. Now kindly come to page 25, instructions section, page 25. Got it. Now kindly see column 3, start with intent. Candidate qualifies for interview. Can sir, কথা বলতে পারছি কলার রাখা অবস্থা এই তো But kindly see, my lord, madam, our first submission is that kindly the scope of the writ petition. My lord, scope of to ascertain the scope of the writ petition, my lord, I will take your lordships to the ground prayer first. To quash, set aside the action and decision of the concerned respondent in accepting non-relevant EWS certificate pertaining to the recruitment process of 2024. Well, what is non-relevant is EWS certificate. I will take your lordships to the pleadings. Then your lordships praying for quashing of the notification dated 20th January 2026. And then your lordships prayer C, to accept only those EWS certificates which are valid and issued for the relevant financial year applicable to the current recruitment process of 2024. Then your losses kindly come to the grounds. I must be fair, what is the grounds there? Page 8, grounds 3, 4, 5, and 6. For that the concerned respondent issued the aforementioned recruitment notification inviting applications for recruitment to the aforesaid post, and the petitioner applied as per the notification. And the recruitment notification clearly states and defines applicability and usage of EWS certificate for the respective candidates. Therefore, he accepted the notification, he submitted to the notification, and he also accepts whatever definition given in the notification. Now, your lordships. 4. As per law and settled principle governing EWS, an EWS certificate must correspond to the relevant financial year and must be valid for the specific recruitment year. But the concerned respondents, all on a sudden, before conducting PTM and PET, the concerned respondent in its online portal has illegally and arbitrarily allowed the acceptance of the irrelevant EWS certificate, which is beyond the prescribed period of limitation without restricting eligibility to the relevant financial year applicable to the current recruitment process. 6. For that, such acceptance of relevant EWS certificates has resulted in a large number of additional candidates being treated as eligible under the EWS category, far beyond the intended reservation framework. And furthermore, till the completion of the recruitment process, this acceptance of irrelevant certificates will cause discrepancy in selection. Now, these are the grounds taken. Now, kindly take your losses the notification. This is for page 15 of the writ petition for post of constable in West Bengal Police. Well, this was issued. Your losses will not get in here the date of issuance, 5th March 2024. Then your losses clause B. In terms of memorandum dated 18th May 2023, backward classes welfare department candidates from economically weaker sections, if shortlisted for interview, must produce income and asset certificate issued by the competent authority, valid for the year 2023, 2024 or onwards, issued for the financial year 2022 or 2023 onwards, during checking testimonials on the date of interview. So, my lord, I am entitled, being an applicant, to submit my EWS certificate on the date of interview, not before that, pursuant to this recruitment. And your lordship, so far, the EWS certificate relates to 2023 validity period. Its financial year will be 2022-23. If it is 2024-25, that will be 2023-2024. So, my lord, he specifically says that this has not been questioned. He submitted to this.
The advertisement is dated 5th of March 24.
Exactly.
So the financial year will be the previous year.
Not necessarily the applicant says otherwise at the time of interview. This is the point, your lordships. This is he has not questioned.
When a financial certificate is issued, irrespective of whether it is used anywhere, if it is for this year, 5th March 2024, then the certificate will be of the previous year.
Financial will be previous year.
Previous year.
Now, my lord's case here. I got it in suppose 2025. This is 2024
Yes.
before the date of interview. So my validity of the certificate 24-25, but it financial year 23-24. This is permissible under
Is it permissible
the advertisement.
under the advertisement?
This is the kindly look at this again. I just read out to your lordships. Must produce income and asset certificate issued by the competent authority valid for the year 2023-24 or onwards.
This
Onwards
is
means the future.
onward me, it can be 29, 30,
My
31.
lord, that's why it's limited on the date of interview. Your lordship has to, my lord, read
The Supreme
all.
Court judgments
One
are
has,
also there.
my lord, Supreme
Very
Court
well.
judgment,
I'll
my
see.
lord, it's governed by the advertisement clause.
All right. You,
This is, my lord, the as I get, my lord.
all right.
Therefore, this is the interpretation permits me. This has not questioned. Then your lordships kindly consider. Page 17. It's not once, repeatedly. Candidates belonging to. Last point, my lord.
Yes,
Note,
yes.
last note.
Ah.
Candidates belonging to economically weaker section must produce income and asset certificate issued by the competent authority as per specified format, valid for the year 23-24 or onwards, issued for the financial year 2023. It relates to, my lord, 23-24 validity, or onwards relates to subsequent future years. Subject to, if a candidate shortlisted for PMT and PET and thereafter under EWS category fails to produce the valid certificate at the time of interview, it qualifies, my lord. It qualifies on the date of interview. My lord, there is judgment, my lord, on the date of interview one could produce, he can be considered. And it specifically says that. It specifically says that. But because it's an economical zone, my lord, process continues for years. 24 ends, my lord, 26. So in between the candidates who gets the certificate, he can be considered also on merit.
What is the mistake of those candidates?
There is
who
no
have-
mistake, he can be considered also. He is not beyond the consideration, but he
Right.
doesn't come on merit. Economical zones, my lord, comes on the reserve category, on the reserve quota. Rest are very based on merit. This is not the case. Someone go without merit comes. Probably I am better meritorious. That's why he is pointing out this.
The zone of consideration, if it is 10 and if it is the advertisement makes it open-ended, then 100
My
candidates
lord,
will
this,
come in.
with folded hand, I'm saying this is not open-ended. It ends on the date of interview.
You never
not
know when the date of interview is.
No, but
So very uncertain.
interview has been held.
Yes.
Interview has been held. Not challenged. He participated also, he or she.
Whoever, it is
Well,
not in
therefore, my
this
lord,
case.
this can't continue like this.
Hmm.
Onwards means, my lord, the next year at best. And that's the situation over here. It's not that your lordship, the authority considers up to last 10 years. Process started in our country, it takes 1 or 2 years. And it has already, they are not issuing the appointment matters, probably your lordship, because of this.
January 4 interview complete.
In the month of January, interview completed. And kindly see, so it has been repeatedly, what I'm trying to tell, it has been repeatedly said in the advertisement. It's not once. Kindly, your lordships, then next, I just take your lordships. Clause 15 at page 25. 14. My lord, page 25, Roman III, under the heading interview. Candidates qualify for interview must submit their caste or category certificate to change his or her category from UR to EWS, SC, ST, all that. Then, your lordships, a request for change of category will not be entertained after the scheduled date of his her interview. This is not open-ended. It ends here.
One of the applicants, it was shown, that has submitted the application form by mentioning UR.
Exactly.
Unreserved.
Exactly. I wanted to point out that also.
Yes.
Then at that, then what happens? I applied, my lord, in 2024. In 25, my lord, I got the certificate. At the time of interview, I produced it. This is valid for the next year only. What wrong, my lord, with that? Unless I'm less qualified. That's the, my lord, pinching issue. And then, your lordships, Kindly consider page 57. This my learned friend has questioned. If I am not wrong, this is the prayer. Without questioning the vegetable. Now kindly see clause E. Again repeating, my lord. Income and asset certificate for candidates belongs to economically weaker section, valid for the year 2023-24 or onwards. This was 24th January issue. Interview held in this month. So this is repetition of the clauses of the advertisement. This is settled law, my lord. Somebody submitted duty. He could have said it that I will not do unless you correct it. I questioning it. This is not the case. And one thing more I will show to your lordships. My learned friend has submitted. No, you have DOP. Just a minute, Mother. এই যে স্যার হ্যাঁ আচ্ছা আচ্ছা টান প্রডিউস করেছে তো টান দিয়েছে তো হ্যাঁ my learned friend produced it. This is called their report to the respondent 1 to my learned friend. This is the state affidavit. State affidavit annexed it. My learned friend placed it. I'm sorry, my lord. Running page 12.
Yes.
The report.
5.3.
Report page exception. 5.3. 5.3. Kindly see. The crucial date for submitting income and asset certificate by the candidate may be treated as the closing date for receipt of application for the post, except in cases where crucial date is otherwise fixed. This text in the clause on the date of interview. So this is a different clause as per the advertisement. Well, the law is well settled. Either rule or the act, not else by the terms of the advertisement. The appointing authority or the recruiting authority cannot also go beyond this clause of the advertisement. I'm not citing judgment, but this is my point, your lordships, against the state also. They cannot deviate from it, neither for me, neither for them. They have to stuck to it. So this is the clause. This also exception, except in cases where crucial date is fixed otherwise. Crucial date is the date of interview for each candidate. So having submitted to this notification, they cannot raise all these. They have not questioned either also. And third, your lordships, the clauses are very clear. That says crucial date may vary, your lordship. It's not that, it's open-ended. It's ended with the date of interview. Had it been a case, my lord, the selection process started to 2014 and ended 2024, probably your lordship, somebody had come, your lordship immediately will quash it, I'm sure. Yes. Because it will be Article 14 and 16. Yes. If a selection process continues for 10 years. That can't. This is the way, my lord, the EW, because this is a benefit giving to the EWS. Process is continuing. If your lordship, it is a case of the respondents that merit is compromised, I will be out. But I am on the zone. I'm on the zone. So I am entitled to be considered in accordance. This is our case. So this is the application we have taken, your losses. We have kindly. I'm just taking
the application and the affidavit, the writ petition also you have argued.
That's what I'm saying about difficulty, your losses. Don't take me amiss. Suppose I lose it before losses. How do I go on appeal? Because unless I'm added, that's why, my lord, normal theory, application for addition of parties allowed, subject to be taken objection at the time of hearing. That we used to
then
take.
I need to know as to why you should be added. What is your...
That's normally, that's now lawsuit has got it.
Yes.
Because this...
Now I have got to know.
Otherwise, I will be out of the zone. Yes. Consideration. That's my case.
My lord, with regard to the contention that made out that we are unsuccessful candidates, I have annexed the list where our names appear and we are in the exception. It is there in the internet also. They can find out this list was published pursuant to the direction passed by the Honorable
Which list? Which list your name is there?
of, my lord, the candidates shortlisted for PMT, PET for recruitment to the post of such and such.
Put
Thereafter,
in the interview stage.
interview also I have annexed. Interview, the interview call letter I have annexed in the written.
Yeah, so
Yes.
you are there in the
Yes,
interview
yes,
also.
Yes. And thereafter, the contention which has been, my lord, argued that the date of interview would be the crucial date is contrary to Gaurav Singh and contrary to Divya also. Kindly sees Divya, the crucial date. Kindly takes up Divya, page 40, paragraph 43. Lordship has read the judgment several times. I will not.
43?
Paragraph 43, Lordship is there. Lordship is having the report.
Yes.
Yes. Paragraph 43, last line. It is not disputed that the closing date of application was 22nd February 2022. Now kindly takes up conclusion. Paragraph 94, 94.1. Several times it has been placed. The reviewers category claiming such and such, such and such, such and such are in possession of such and such. Further, as required in rule such and such, such and such, such and such. Any candidate not in possession of income and asset certificate to the prescribed format mentioned cannot claim EWS category equally, such and such. The documents in possession as on 26 February 2022.
What would be your submission to the explanation given by the applicant that
Is
advertisement itself
yes,
has an exception clause?
yes.
So you say that this is contrary to
Advertisement
Divya.
also is having a clause of the closing date of application. Kindly cease. So that is the crucial date. Kindly comes to page 21. 21. Page 20. Period for application.
Page 20.
Page 20. Period of application. Application window for submitting applications through the online mode only will remain operative for the period of Ato to Ato.
No, but then
This is the
on
crucial date.
well, you say that this is last date is a crucial date, but the according to the applicant, as the advertisement itself mentions that the date of the interview would be the date on which the certificate has to be there.
Produced.
It has to be there on that date.
It doesn't say that which year, where. It has to be produced. The person who will be coming into the interview process will be having a certificate in his hand, and that certificate will be produced at the time of interview. And onwards means till this date. In any case, even if it has to be construed of the previous financial year, from 1st April 2024 is the subsequent financial year. But if it is to be read in accordance with the advertisement, if it falls, if it is their case that the exception clause will be there, if otherwise mentioned in the advertisement, this will be this date. So crucial date is the main point. Otherwise, the entire object of EWS course. That will be the
Where is the state?
state, I think, will come.
Yes.
So the junior government advocate is there. Let him start, my lord.
My lord, GP, my lord, will want, my lord, places are.
তুই আয় না।
My lord, my lord,
আমি
he's
ডিসকাস
placed, my
করে
lord,
পাঠাচ্ছি।
finance
এই
board,
এটা
my lord,
আমার এদিকে চলে গেছে।
My lord, because my lord, the London Advocate General was also under the impression it should be taken up, my lord, on the 21st, my lord. So, my lord, that,
You know, the only problem is
my lord,
the link has been given and candidates with legitimate expectation are putting in their documents.
my lord.
So if any right accrues in their favor, then it becomes a problem.
My lord, at this stage, subject to what falls from my lord, right? may not, my lord, accrue at this stage, my lord.
Yes, till tomorrow is the date for submitting the EWS certificate.
My lord. My lord.
Some
My lord has seen
already
today's,
submitted.
my lord has seen today's notification, my lord. The
Yes.
cutoff date, my lord, has been given, my lord. That clarification, my lord,
Must have been issued before the date of the interview.
yes, that, my lord, here to lay all matter, my lord, this should have
The
been
date of the interview was in
in
sometime
February.
January or
January 20.
January.
January and February.
January.
That is
February.
2026.
February.
This year,
20th January.
2026.
Uh-huh.
জানুয়ারিতে
My lord,
শুরু হয়েছিল
my
ফেব্রুয়ারিতে
lord,
শেষ।
January and February 2026, my lord. My lord, now, my lord, this is basic, my lord, a reiteration of a stated position, my lord, of a position which is
Well, by this document, then today's document, I think whatever has happened has happened.
my lord. My lord, this should put matters,
Fresh urgency, possibly there is no scope at this stage.
my lord.
Because if the date of the interview is long over, so
My lord.
whatever has happened has happened.
Yes, my lord. So,
What is the stage of the recruitment process?
Everything
lord,
is complete.
Interview is over.
Everything
And
complete.
only appointment letter.
They will only issue appointment letter. There has been an agitation. That is why they are so fearful on the last occasion after
the
the
result
judge,
has
after
not
my
yet
lord,
result has not yet been published.
moment the result, after this they will publish the result.
Result has not yet
So
been
there is an
published.
order of court. Any steps taken shall abide by the result of the
So,
recruitment.
my lord,
That will not do.
result has not yet been published.
They will
My
be
lord, so
getting
there is
right
no
thereafter. they will be
pressing
inviting
urgency, my lord.
subsequent
Which-
litigations.
Has any order been passed in this matter, as has been passed in the SLST matters, to put up a disclaimer as to any steps taken will abide by the result?
Disclaimer is not
Not
there.
there.
is not there.
It is not.
Order is there.
Order may be there, but then you put it up, everybody is not there before the court.
And my lord, and my lord, what they will do is that moment they publish the list of successful candidates, according to your lordship, a right would accrue in favor of those candidates who secured a position in all India rank. So this is
The
So
moment
this
the
will-
ranking
So,
list
my
is
lord's
published,
order is there.
so
My
therefore,
lord's, my lord,
I don't know. They will
lord,
be in
it is
further
subject to
suit.
the
What
result,
why they are
subject to
saying
the-
all these things?
my lord, subject to
Why
the
the only one agitation? They are so fearful. One
Why?
day agitation.
আরে
wait,
কোর্টে অ্যাজিটেশনের কি ব্যাপার?
আরে agitation হয়েছে বলে
wait,
তো
কোর্টে
আমাদের
অ্যাজিটেশনের কোনো ব্যাপার নেই।
Yes.
অ্যাজিটেশন হোক যাই বাইরে যা হবে।
yes, yeah, yes.
So,
The
my lord,
order is there.
my lord,
It's different, but everybody is not party over here. The moment you publish the results,
my lord,
a right accrues in favor of the candidates
my lord,
impaneled,
Maybe a right,
right?
let them
You put up a disclaimer,
my lord,
as has been done, and in the SLST matters, there is already a notice in the official website of the board, recruitment board. And also, if you will have any other websites, I do not
made in your to my lord, tomorrow subject to my lord's convenience, my lord, because
extremely difficult.
I understand,
I
my lord,
time you can see
I understand, my lord. We've been, my lord, seeing,
evening, the
see,
second
we've been, my lord,
has gone
on this, my lord,
this matter.
my lord,
The disclaimer can be given.
My lord,
No, no, disclaimer
kindly,
is
my lord,
correct.
my humble submission would be let them not publish the subsequent successful list.
subject to the result.
Hears it out on 21st. I will stay. I was supposed to go. I will stay. On 21st, I was having a difficulty. That is why your lordship kept it on 19th. I will stay.
Like these notification are substantiate our case.
Yes, it is substantiating your case.
To substantiate our case. That the interview date is the crucial.
Date of the interview.
Individual petition গুলো আছে। So that will that
Let there be an order that let them give the options, but they will not publish, my lord, the successful list.
my lord, on
They
this
will not be creating any right
My lord.
in favor of candidates whose candidature would, if I succeed, will be annulled, because we are at the end. It is not that we have come at the last. We are matters as being here heard.
Yes.
my lord, on this point, my lord, I'll just, my lord, we'll just have to peruse my lord's orders also, my lord, in whether, my lord, we'll just, my lord, tomorrow, my lord, subject to,
What you want
on
to
this
see?
point, my lord, on this point,
Which
what
point?
that fell from my lord, this putting it up on the website, my lord, we need to know what
Nothing
websites.
for you to see, because it is not there. Had it been there, these candidates would have known.
My lord, they are much better aware of.
No, no,
many
no.
of-
They
many
will
of
come and
us,
say
my
that we are not a party and all these things. These are
They are, my lord,
You have come in later on.
my lord,
They are there since beginning. They know the facts far more than you do.
my lord, yes.
Because when a party comes to you, a litigant comes to you directly,
My lord,
you get to know from the client and things stay in your mind.
my lord.
And you have to read each and every paper to find out what is there. So it makes a hell lot of difference, right?
My lord,
So it's better you put up a notice and you do not publish the final
my lord,
result now.
my lord will be pleased to my lord once, my lord, because this, my lord,
It will not create any problem.
my
It's
lord,
pending for quite some time.
I understand, my lord, but
Wait,
my lord
the
will be pleased, my lord.
create problem.
My lord,
Let-
just tomorrow to be
Application
mentioned, my
would
lord, to be
create
mentioned once, my lord, only on this.
purpose.
On
To be
my lord,
mentioned,
for
yes.
my lord's order, my lord, will please, my lord. Otherwise, my lord, for this, my lord, putting it up on the website, my lord, and I need to, we'll just need to check up on which websites are available. My lord. I'll just take it.
Whatever website is
My
available,
lord will, my lord will kindly be, my lord, otherwise,
business of the court will not permit.
my lord, tomorrow,
And
once,
Thursdays, you know, my
I-
head, there is a lot of pressure. Thursdays, all contract matters
my lord,
are there.
otherwise, my lord,
What is the use of passing
lord.
order if the orders are not complied with?
I bow down, my lord. Orders have to be complied. And with, no, my lord, with my lord, orders are generally not complied with. My lord.
Generally compared. অন্যগুলো করেছি
একটু
হ্যাঁ জেনারেলি কম্পেয়ার অন্য
শোনো না না এটা হঠাৎ করে আমার এই যে কি আছে এটা আমি
Then it's senior counsels representing the petitioner and the applicants in Can 2. What is Can 1?
can one has been allowed.
Acha, Can
Addition of party.
Can 2. Stop. The according to the petitioners, petitioner বোধহয় একজন আছে. According to the petitioners,
because can one allowed?
Can one petitioners.
acha.
Petitioners হবে তো।
And they have been implemented as petitioners.
Yes.
Yes, yes.
I don't know whether
Well,
the
petitioners.
এ করেছে কি
According to the petitioners, the recruiting authority
শুরু করো আমার বউকে যেমন বলি
ought not to permit
can one অর্ডার হয়ে গেছে ইমপ্লিমেন্ট করে
candidates to rely upon EWS certificate issued after the crucial date, that is the last date of filing the application, which is date is
5th April.
5th April 2024. Stop. According to the learned counsel representing the applicants, the EWS certificate issued prior to the date of the interview could be taken into consideration. Stop. It has been brought to the notice of the court that the interview was held in January and February 2026. Stop. The recruitment board has issued a notice on 18th of August 2026.
uploaded today I think.
My lord, a copy.
Yes, there is
Oh,
a copy. Wherein it has been mentioned that for the that EWS certificate issued before the date of the interview of the concerned candidate will be taken into consideration. Stop paragraph. After hearing both the parties at length, the court is of the opinion that the applicants be added as party respondents in the writ petition. Stop paragraph. It will be open for the applicants to file. Would you like to file opposition?
not a yes matter kindly allow us.
It's a point of law.
Yes madam, but we relate certain document in our applications so that we can
Everything you have mentioned in your affidavit,
applications, in my applications.
in the affidavit that you have filed to the application, you have disclosed everything.
In application, I have to disclose everything.
Yes.
That will only be Lordship copy paste into your opposition.
No, I'll treat those to be as the
As your
affidavit
Lordship.
because all documents are
Yes,
there.
my application may be treated as an
It is an
Right.
application and supplementary affidavit may be treated as
application supplementary.
affidavit may be treated as opposition. Yes, yes.
The
Will not file
applicants
it
have
different.
already
We have already
disclosed
filed.
their stand
Certified.
in the application seeking addition of party and in the supplementary affidavit filed by them. Stop. The documents and the averments made in the application and the supplementary affidavit
Dated 13 July
treated
2026.
shall be taken into consideration for the purpose of adjudication of the writ petition. Stop. Next. Let copy of the report. Let copy of the report of the state and other documents supplied to the learned counsel for the applicant.
Not already supplied. Mr. Somesh has already been given.
Not supplied earlier.
We have supplied. ঠিক আছে, not
Exception.
প্যারাগ্রাফ দিয়ে লিখুন যে accommodation has been sought for on behalf of the learned government pleader. Stop. The court has been informed that the result of the recruitment process has not been declared till date. Stop. Paragraph. As the court is adjudicating the issue, comma, let the result not be disclosed
My lord,
till
my lord will please, my lord will be, my lord, I am just playing the role of a night watchman, my lord here.
till
My lord will kindly be, my lord.
2026.
My lord, on this, my lord, I humbly pray, my lord.
Earlier. Stop. The
My lord will kindly be, my lord. Please to bear with us, my lord.
directed to put up a public notice in their official portal/website disclosing that any steps taken in the recruitment process shall abide by the result of the writ petition. So,
My lord, if that be the case, my lord, then
list the matter for further consideration on
21st.
it will not be possible.
As you lordship.
no, my lord has, we are publishing it. My
We
lord,
are-
result, my lord, stay on result, my lord,
Uh,
publication.
An order has to be passed by the court. You have to give me this time.
My lord,
Till an
I
order
will,
is
my lord.
release the matter for further consideration on 11th of September.
আমি আর কি করবো, date fix.
Not kindly fix a time. It will.
And my lord, the
official
other matter,
Hearing
may I,
matters are taken up at
my
2
lord,
o'clock.
may I
It's a
close the
Friday.
other matter?
It's
my
a
lord.
Friday.
My lord, may I close the Chandandhara matter on that horizontal reservation?
No, sir. I have got other work.
Well, kindly then keep the Chandandhara matter on 21st as
It is
pleased.
there in the list. It will remain in the list.
At 2 it is there.
দাঁড়াও, এইগুলো ওর সাথে যাবে। I have to write.
Because I have already cancelled my program.
And
on 21st.
today morning I have reserved one order. It has
Yes,
to be
yes, and-
prepared.
But it is 81 is 2 fixed. It will be there 2 and 21st.
It is there in the list. It will remain in the list.
Montu Manna is not there. Joshua is hearing Chandandhara only. So Chandandhara is.